Thank you. This hearing is in the matter of case number CFI 054-2018 and is being held by way of video conference before His Excellency Deputy Chief Justice Adil Madhani. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Dentons & Co. Lead counsel is Mr. James Wheel. The second defendant is represented by DLA Piper Middle East LLP. Lead counsel is Mr. Colin Mulderick. Would the judge and counsels please confirm that the situation is as I have stated?
Correct.
Correct.
Thank you very much. I understand we have today implication from the second defendant to purge the contempt order and to apply for relief from sanction, mainly the reference to the Attorney General.
That's correct, Your Excellency.
Unless there is any housekeeping matters, we can proceed with the applicant.
Your Excellency, there is a point of housekeeping just in terms of timing for today.
Right.
We haven't quite worked out beforehand the order of the applications, or indeed the time allowed by the parties in respect of them. As Your Excellency has correctly pointed out, there is the purge application, then there are submissions in respect of an appropriate sanction, if any. Mr. Mehta, the second defendant, is appearing to give evidence. It does seem to us, in respect of the order of the applications, the purge application suitably should come first, because of course that will have implications for the question of sanctions. But then there's the question about when Mr. Mehta's evidence is brought on, because of course Mr. Wheel may agree with this. I'm not quite sure what his position is, but his evidence may well be important to the question of sanctions and the purge application as well, because of course it may be that we need to make submissions having heard from Mr. Mehta.
Yes, in my submission, it makes sense for Mr. Mehta's evidence to be dealt with straight away. I have to say I'm concerned that that evidence could take some time, given that there is an interpreter who doesn't appear to have any court accreditation, but we'll just have to see how we go with that. But subject to Your Excellency considering another course, in my submission, we should just get on with Mr. Mehta's evidence.
Well, if I may understand that, is there going to be a cross-examination of the second defendant?
Yes.
So that means the second defendant would give short, maybe opening statement. Then you would do short second opening, maybe, or we just go straight forward and.
I think straight into the evidence, given the time constraints. We've set out fairly detailed skeleton arguments in relation to submissions.
Your Excellency, I just make one point, and we're happy to bring on the evidence, as Mr. Wheel suggests this morning. There is a point about timing for the applications. We heard for the first time yesterday from Dentons, who are for the bank, that Mr. Wheel may need half a day for cross-examination. And the proposal seems to be that the remaining time would then be split between the parties for submissions. And I'm afraid, Your Excellency, that won't work for Mr. Mehta. I will need, I'm afraid, 2 hours for my submissions in order to deal with both the purge application and to deal with sanctions. And we say that that will be required given the gravity of the applications and their potential consequences for Mr. Mehta. I want to put the point as highly as I think it's appropriate to do, which is that it would obviously be highly prejudicial to him to have his submissions effectively in defence of criminal proceedings curtailed because of a belated indication that half a day of cross-examination will be required. Now, I have no objection to how Mr. Wheel wants to use his time, and I appreciate he will need a little more for cross-examination, hence why I'm willing to give up a bit of my time on a fair division. But the parties will need to cut their cloth, and I just want to make the point now that I really will need 2 hours to deal with the two applications.
Yeah, how do you inform me earlier? Like, at least we would have started this hearing maybe earlier, 1 or 2 hours earlier. But and then, as you may know, the registry here closes at 4 o'clock Dubai time, so that gives us 5 hours from now. Where maybe that includes short break. I'm not worried much about the break itself. But half a day plus 2 hours for your submission, and then another submission from Mr. Wheel as well. They wouldn't have much time for that.
That's obviously an unworkable proposal from my learned friend. Can I just make two observations? The first is this. The hearing was originally given a time estimate of between 1 and 2 days. Now, in my submission, it would be unfair on either party for them not to have a fair opportunity to develop their submissions. And so, if necessary, as long as evidence is completed today, the sensible course may be to reconvene a second day so that both parties have a full and fair opportunity to make their submissions. The other observation I make is that my learned friend's original time estimate for his applications was 30 minutes. That has now increased to 2 hours. And the obvious concern for our part is that my learned friend is simply seeking to fill the time so that we're not able to make any submissions over the course of today. So with those observations in mind, we're in the court's hands.
Well, what I'm thinking, if we can take, I don't know, that depends on you, Mr. Wheeler. I mean, if we can have the witness cross-examined in 2.5 hours, then we can break for 1 hour. Then we can give each party's 1 hour submission toward the end of this day. I think that should manage our time for today. That's what I can see this the best way of dealing with the matter.
I'm grateful.
Your Excellency, sorry, there's just one point I would like to make in response to Mr. Wheel. It was only canvassed for the first time yesterday that he would require half a day for cross-examination. There was a direction for 1 to 2 days, but when 1 day was listed by the registry, there was no suggestion by my learned friend or by the bank that more time would be required. And with respect, that point could have been raised beforehand. It was originally canvassed that 45 minutes would be required for submissions, but that was before the service of skeleton arguments and before the very large gap between the parties' positions was firmly established. And I just reiterate, Your Excellency, that an hour really will be very difficult for me to get through submissions, particularly considering the gravity of what's being considered by the court today.
Well, I mean, given the fact that I am aware of the background of the case, that one thing. I mean, it's, fairly for me, it's. I mean, I'm not underestimating your order, your application. I mean, but given the fact I'm aware of the background, I'm the one who issued a lot of orders in this case in the past, and I have read your submission carefully. I have read the witness statement and the affidavit itself. I've read both parties' skeleton arguments. So that's supposed to comfort, I mean, the time frame for today. And but I mean, as it was indicated before, like none of you were like have indicated he wants to go for 2 or 3 hours for submission. Having the written submission in hand, there is another possibility of giving you a chance to have a short closing submission as well in hand. So I think now, and since we have sort of disagreement, I would say I would allow the cross-examination for 2.5 hours maximum from now on. Then we will break for half an hour. Then I will give each of you 1 hour, maybe slightly more, 10 minutes, 15 minutes if it's required. But we must finish before 5 o'clock Dubai time.
Grateful.
So you may call your witness, Mr. Muldren.
Your Excellency, I'd like to call Mr. Mehta. He should hopefully be on the call. Good morning, Mr. Mehta.
Good morning, sir.
I would just ask, for the benefit of the translator, I think hopefully is also on the call, that you speak slowly and clearly.
Yes, sir.
And that you leave appropriate gaps to assist the translator whilst the translation is happening.
मैं आपसे कहूंगा कि अनुवाद के लिए आप धीरे बोलें और स्पष्ट रूप से बोलें और थोड़ा रुक के बोलें ताकि अनुवाद अच्छे से हो सके।
हाँ जी।
Hello, I
Yes, sir.
apologize to interrupt, but I would need both the interpreter and the witness to be sworn in. Just to begin, can you please confirm the language that you will be translating to?
हिंदी
I will be translating towards Hindi and from Hindi to English.
Okay, thank you. So the interpreter would need to please repeat after me. Would you like to swear in today? Would you like to perform an oath or affirm?
I'm sorry, I did not hear that. May I ask for a repeat of the last sentence, please?
Yes, would you like to affirm or swear today?
I would like to affirm, please.
Okay, please repeat after me. I solemnly affirm and declare
I solemnly affirm and declare
that I will faithfully interpret from Hindi to the English language
that I will faithfully interpret from Hindi to the English language
and to English to Hindi
and to English to Hindi
to the best of my knowledge,
to the best of my knowledge,
to assist the proceedings before this court
to assist the proceedings before this court
in an accurate manner.
in an accurate manner.
Thank you. I would like the witness to also please repeat after me. Will he be swearing in or affirming today?
मैं गवाह से भी कहूंगी कि वो मेरे बाद बात दोहराएं। वो शपथ लेंगे या फिर वो एक पूंजी करेंगे, एक अफर्म करेंगे।
अफर्म करूंगा
Okay,
I
sir,
will
I would
affirm.
need, thank you. I will need you to state your name and occupation for the record.
मैं आपसे अनुरोध करती हूँ कि आप अपना नाम और अपना पेशा बताएं।
मैं हितेश कुमार मेहता और फिलहाल पेशे में तो मैं बोल सकता हूँ मतलब बिल्कुल रिटायर्ड हूँ।
My name is Hiteshkumar Mehta and I have retired.
Thank you. Please repeat after me. I solemnly affirm and declare
ठीक है, मेरे बात दोहराइए। मैं ध्यानपूर्वक ये अफर्म और घोषणा करता हूँ
मैं ध्यानपूर्वक ये अफर्म एंड घोषणा करता हूँ
that the evidence I shall give today will be the truth, the whole truth, and nothing but the truth.
कि जो भी मैं प्रमाण यहाँ पर पेश करूंगा वो सच होगा और सच के सिवा कुछ नहीं होगा।
मैं जो भी प्रमाण यहाँ पेश करूंगा वो सच होगा और सच के सिवा कुछ नहीं होगा।
Thank you.
धन्यवाद।
Thank you, Shara. You may introduce your witness, Mr. Marin.
I think it's for me, Your Excellency, just to bring Mr. Mehta to his affidavit, if that's okay as a preliminary step. Mr. Mehta, do you have an electronic bundle of documents that's been sent to you?
श्री मेहता, क्या आपके पास इलेक्ट्रॉनिक बंडल का दस्तावेज है जो आपको भेजा गया था?
हाँ, मेरे पास प्रिंट है उसका।
Yes, I have a print of that.
And if you turn in that bundle to volume B, tab 3, page 12, and if it's convenient, it's actually on the screen for you. If you can see that. Do you see that?
क्या आपको ये दिख रहा है?
हाँ।
Yes.
And do you recognize this document?
क्या आप ये दस्तावेज पहचान पा रहे हैं?
हाँ जी।
Yes, sir.
And what is it, Mr. Mehta?
और ये दस्तावेज क्या है श्री मेहता जी?
ये मैंने जो एफिडेविट करी है वो है.
This is the affidavit from my side.
And if you could turn to volume B, tab 3, page 36, which is the bottom of this same document. And again, if it helps, just you can look at the screen.
आप वॉल्यूम 3 पेज 36 की ओर जाएं और ये एकदम आपके अंत में होगा डॉक्यूमेंट के और आप स्क्रीन पे भी देख सकते हैं.
And do you see the signature there, Mr. Mehta?
क्या आपको यहाँ पर हस्ताक्षर दिख रहे हैं श्री मेहता?
हाँ जी सर.
यस सर.
And whose signature is that?
और ये किसके हस्ताक्षर हैं?
ये मेरे हस्ताक्षर है.
These are my signatures.
And are the contents of this affidavit true to the best of your knowledge and belief?
और जो भी आपने इस एफिडेविट में लिखा है वो आपकी जानकारी के हिसाब से बिल्कुल सही है.
हाँ ये सही है.
Yes, it's correct.
And if you could now please turn to volume B, tab 5, page 81, and again that will come up on the screen for you.
और अब आप वॉल्यूम बी टैब 5 पेज 81 पर जाएं और ये आपके सामने भी होगा प्रस्तुत स्क्रीन पर.
And do you recognize this document, Mr. Mehta?
हाँ जी.
Sorry, the translator's muted, so I don't know whether there was a.
Yes, sir.
And what is this document, Mr. Mehta?
और ये दस्तावेज क्या हैं श्री मेहता?
ये मेरे द्वारा की गई हुई दूसरी एफिडेविट है.
This is the second affidavit from my side.
And if we could then turn to volume B, tab 5, page 89 of the bundle. And again,
और
Mr. Mehta.
अब हम अगर वॉल्यूम बी टैब 5 और पेज 89 की तरफ जाएं बंडल में मिस्टर श्री मेहता.
हाँ जी.
Yes, sir.
I think, Mr. Mordega, we can skip this classical introduction unless Mr. Whale and Mr. Hogan would have any objection to that. There is another thing I would like to bring to your attention. I'm wondering whether you would continue sharing the witness statements on the screen, because we do have a problem that this recording will go public, probably on YouTube as well. So usually this evidence is not for publication or for public domain. I wonder if the witness can use the bundle from his side, whether electronic or paper bundle, unless both parties, especially the second defendant, agree that the evidence go public with no objection from the side.
You actually, my understanding is that Mr. Wheel and Mr. Hogan will be sharing documents during the cross-examination of Mr. Mehta on the screen. Mr. Mehta, I believe, has an electronic bundle available. So if it were the case,
my worry only his affidavit and witness statement. That is the only document that we usually do not publicize. Any other document, we don't have any harm of both. Yeah, that's the only one. Unless you give me both, you consent to this, I would have no problem.
You actually, I can cut through this now because I can get Mr. Mehta to confirm. They only had one question left for him, which was to confirm the accuracy of his second affidavit. And the only point on that, Your Excellency, is that there was a proposal jointly from the parties that documents shown to Mr. Mehta may be blurred out for the purpose of publication. But I suspect it's a point we might have to deal with later.
Could I just raise another important procedural point?
Yes.
I appreciate that Mr. Mehta is represented, and so I assume he's been properly advised. But strictly speaking, he has both a right to silence. He is not compelled to give evidence in these proceedings, and he is also not required to answer any questions which may incriminate him. I just want to make that clear for the record, and I'd be grateful if Mr. Mulderig would confirm that Mr. Mehta has been fully advised of those two important procedural rights.
Thank you very much. That's very important,
confirm
Sumit.
We can confirm that. Thank you for Mr. Wheel's promise in that regard. You actually, what I just proposed to do then, just the very last question for Mr. Mehta is just to confirm then that the second affidavit is true to the best of his knowledge and belief. If you could just answer that question.
क्या आप ये हमें बता सकते हैं कि जो आपका दूसरा एफिडेविट था वो आपकी पूरी जानकारी के हिसाब से सही है?
मेरी जानकारी के हिसाब से सही है.
To the best of my knowledge, it is true.
Thank you, Mr. Mehta. Mr. Wheel, who is the counsel for the bank, will now have some questions for you.
धन्यवाद श्री मेहता. अब श्री व्हील आपसे कुछ सवाल पूछेंगे.
Yes, Mr. Wheel, the witness is yours. For a management of the time, I would like to just require from you that to have a very significant, a very important question to the witness, just to
and
keep up with the time. Yes.
It's 25 past 8 by my clock, and I'm conscious of the 2.5 hour limit that's been put upon me.
Yes.
Mr. Mehta, where are you currently based? What address are you giving your evidence from, please?
श्री मेहता, अभी आप कहाँ पर हैं? किस एड्रेस पर के यहाँ से आप अपना प्रमाण पेश कर रहे हैं?
मैं अभी इंडिया से अपना प्रमाण पेश कर रहा हूँ.
I am presenting evidence from India.
Full address.
पूरा पता बताइए.
अभी मैं मतलब एक दोस्त के घर से ये मेरे प्रमाण दे रहा हूँ.
I am giving evidence from a friend's house.
What's the address?
आप पता बताइए.
मैं वो मतलब कहना नहीं चाहूँगा.
I do not want to say.
So you're refusing to answer my question?
क्या आप मेरे सवाल का जवाब देने से मना कर रहे हैं?
मैं जितना बता सकता था मैंने बता दिया.
The interpreter lost Mr. Mehta's voice for a moment. May I please ask if Mr. Mehta can repeat? Do I have permission to say that to Mr. Mehta?
I think we can move on. Mr. Mehta, it's a matter of record that Mr. Mehta refused to answer my question. I'd like, please, to turn up page 709. This is a paragraph from the claimant's particulars of claim.
अब हम 7वें पेज की ओर जाएंगे जहां पर आपने पैराग्राफ में क्लेम के ऊपर बात की है.
And if you could zoom in, can you see paragraph 21? What's said there is that on the 27th of June 2018, Mr. Malik contacted Mr. Mehta requesting payment of the sums outstanding. Mr. Mehta informed Mr. Malik that the outstanding amount would be paid within 15 days. The outstanding amount was around $30 million. Interpreter, I'd just like you to confirm that Mr. Mehta is able to read paragraph 21.
आप 21वें पैराग्राफ में आप देख सकते हैं 27 जून 2018 श्री मलिक ने मिस्टर मेहता से संपर्क किया था. उन्होंने बची हुई रकम की बात की थी और ये जो पेमेंट था ये 15 दिन में होना था, $30 मिलियन बचे हुए थे पे करने के, तो क्या आप ये देख रहे हैं?
ये कौन से मेरे विटनेस स्टेटमेंट में है? आई जस्ट वांट टू
Which,
रिफर, मैं रिफर करना
which,
चाहता हूँ।
which of my witness statements has this? I would like to refer to it, please.
It's not a witness statement. It's a statement from the particulars of claim. I just want him to read paragraph 21.
This is ये जो गवाही का जो प्रमाण है ये उसमें से नहीं है। मैं बस चाहता हूँ कि आप 21वें पैराग्राफ को पढ़ें।
Can he read it?
थोड़ा सा उसको एनलार्ज कर सकते हैं?
Can the screen be can we zoom into the screen, please?
हाँ, अभी आप क्वेश्चन पूछिए।
No, please ask the question.
Have you read paragraph 21?
क्या आपने 21वां पैराग्राफ पढ़ लिया है?
हाँ,
Yes.
Your statement that the outstanding amount would be paid within 15 days was a lie, wasn't it, Mr. Mehta?
तो जो आपने बात कही कि 15 दिन में आप बची हुई रकम लौटा देंगे, वो झूठ थी, है ना श्री मेहता?
मतलब मैं समझा नहीं क्या एग्जैक्टली पूछना चाहते हैं।
I did not understand what you are trying to ask.
I'll try again. Your statement that the outstanding amount owed to SBM would be paid within 15 days was a lie, wasn't it?
मैं आपसे फिर से पूछूंगा, आपने ये जो घोषणा की थी कि आप बची हुई राशि SBM को 15 दिनों में वापस दे देंगे, ये एक झूठ था, है ना?
मैं वही कहना चाहूंगा कि ऑनरेबल सर के मेरे को उनका जो क्वेश्चन है वो एग्जैक्टली क्या पूछना चाहते हैं वही समझ में नहीं आ रहा है।
That's what I would like to say, Honorable Sir. The question that is being asked to me is not something I understand.
And after you made that statement, you fled from the UAE to India, didn't you?
और जब आपने ये घोषणा की, आप UAE छोड़कर इंडिया भाग आए, है ना?
योर ऑनर, ये काउंसिल के क्वेश्चन मतलब कैसे पूछे जा रहे हैं मेरे को समझ में नहीं आ रहा है।
Mr. Will, if you allow me, can you ask him if he never had the intention to repay the bank's money at all?
I'm happy to do so. Mr. Mehta, I suggest to you that you
Shri
had no
Mehta ji.
intention of repaying the money that was owed to SBM. Do you accept that?
श्री मेहता, क्या आप ये मानते हैं कि जो भी पैसा आपको SBM को देना था, वो आपको देने की कोई इंटेंशन नहीं थी?
ये गलत है। ये बात गलत है।
That is not true.
And out of the $30 million odd, you or Renish have not paid a single cent that is owed to SBM. Do you accept that?
The interpreter would like the question to be repeated, sir, since the voice was cut off.
Out of the 30 million or so dollars that is owed to SBM, Mr. Mehta and Renish have not repaid a single cent. Does he accept that?
I'm afraid, sir, your voice did not reach the interpreter.
His Excellency, can you hear me clearly?
Yes, I do.
I'm grateful. I will try one more time.
Yes.
Out of the $30 million or so that is owed to SBM, does Mr. Mehta accept that he and Renish have not paid a single cent?
जो $30 मिलियन की रकम आपको SBM को देनी थी, तो आप इस बात को मानते हैं कि आपने या रमेश ने इसमें से कोई भी पैसा नहीं दिया?
सॉरी, सुनाई नहीं दिया।
माफ कीजिए, sorry, I did not hear it. The interpreter is asking if she can repeat the question to Mr. Mehta.
Yes, please, quickly.
जो $30 मिलियन की रकम आपको SBM को देनी थी, वो आपने या रमेश ने उसमें से एक भी पैसा नहीं दिया उन्हें, ये बात आप मानते हैं?
मतलब एग्जैक्ट अमाउंट तो जो भी डॉक्यूमेंट्स में है अकॉर्डिंगली जो भी है, तो मैं मतलब एग्जैक्ट 30 मिलियन या क्या, बट एसबीएम को मेरे को डेब्ट चुकाना है, वो बात सही है।
So the exact amount is there in the documents, and it is true that I need to pay back the debt.
And he has not paid a single cent. Does he accept that?
और आपने बिल्कुल इसमें से बिल्कुल एक पैसा भी लौटाया नहीं है, क्या आप ये बात मानते हैं?
हाँ, उसके लिए जो भी सिचुएशन है वो आप सबके सामने है, तो और मैं क्या उसके ऊपर बता सकता हूँ।
The situation as it's
I haven't heard the answer from the interpreter.
Please, could you repeat the answer, interpreter?
The situation as it stands is clear to everyone. What can I say about it?
No, he got to confirm that he didn't pay anything. We didn't need
आपको
indirect
ये
answers.
हमें प्रत्यक्ष रूप से जवाब दीजिए।
हाँ, जो उसके बाद जो भी सब हुआ और मेरे को यूएई छोड़ के जाना पड़ा और यूएई नहीं जा पाया वापिस, और जो भी सिचुएशन हुई उसकी वजह से मैं एसबीएम को वापिस पेमेंट नहीं कर पाया हूँ।
After everything that happened, I had to leave UAE. I was not able to return, and because of this situation, I was not able to repay.
That's nonsense, isn't it, Mr. Mehta?
ये
You have
बिल्कुल
access
बकवास
to
है।
funds to repay some money, even if you can't afford to pay the full amount.
ये बकवास है मिस्टर मेहता, है ना? क्योंकि आपके पास पैसा देने के लिए कुछ तो रकम है। अगर आप पूरी नहीं राशि दे पा रहे थे, आप कुछ राशि लौटा सकते थे।
योर ऑनर, ये क्लेमेंट का मानना गलत है।
Your Honor, this is incorrect, what the claimant is saying.
I want to move on. Please, can you tell me the date on which you first became aware of the worldwide freezing order?
क्या आपको ज्ञात हुआ कि एक दुनिया भर में एक फ्रीजिंग ऑर्डर दिया गया था?
हाँ, वो जब मैं केस में अपीयर हुआ तब मेरे लॉयर ने बताया।
My lawyer informed me when this happened.
It's not my question. What was the date on which Mr. Mehta became aware of the freezing order?
कौन सी तारीख को आपको इस दुनिया भर के फ्रीजिंग ऑर्डर के बारे में पता चला?
एग्जैक्ट तारीख तो मेरे को याद नहीं है, बट जब मैं ये केस के लिए प्रोसेस स्टार्ट किया तब मेरे लॉयर ने थोड़े दिन के बाद मेरे को बताया था।
I do not remember the exact date. After the process started,
Repeat the answer, interpreter. Repeat the answer, interpreter.
I do not know I do not remember the exact date, but it was only after a couple days after this process started that my lawyer informed me.
A couple of days, around what? A week, less or more?
आपने कहा कि कुछ दिन बाद आपको बताया, इसका क्या मतलब है? एक हफ्ता, उससे कम, उससे ज्यादा?
मेरे ख्याल से उससे ज्यादा।
I think it was more than a week after.
Approximately how long?
अनुमान लगाते हुए कितना समय?
देखना पड़ेगा, सही में बिल्कुल ऐसा याद नहीं है कितना समय।
I will have to check. I do not remember the exact time.
And when you say it was shortly after the process started, by that do you mean the date of the freezing order, which is the 2nd of August 2018?
तो जब आप कह रहे हैं कि कुछ समय प्रक्रिया शुरू होने के बाद, तो इसका मतलब ये है कि जो 2 अगस्त 2018 की तारीख है, उसके कुछ समय बाद?
ये 2018 का तो मेरे को बिल्कुल पता नहीं है। मेरे ख्याल से 2020 में जब मैंने ये पढ़ा और गूगल पे ये फ्रॉड क्लेम का, तब मैंने लॉयर को अप्रोच किया, तो ये कहीं 2020 की बात है।
I am not sure about 2018. In 2020, when I read about it and I read about the fraud claim on Google and I approached the lawyer, is what I'm referring to.
Is it your evidence that you discovered the existence of these proceedings by chance when you were surfing the internet? Or was there something that caused you to search for judgments in this case?
क्या ये आपका प्रमाण है कि जब ये प्रक्रिया चल रही थी, तो आपको अपने आप जब आप इंटरनेट पे सर्च कर रहे थे, तब आपको ये चांस के थ्रू मिल गया, या फिर आप पहले से ही इसके बारे में जजमेंट्स ढूंढ रहे थे?
नहीं, ये इंटरनेट पे सर्च कर रहा था तभी मेरे को मिला ये चीज.
I was searching the internet and that's when I found this.
That's a lie, isn't it, Mr. Mehta? You only searched the internet because you were aware of an immediate judgment that had been made against you on the 27th of September 2020.
ये झूठ है ना श्री मेहता, क्योंकि आपने तभी इंटरनेट पर ये सर्च किया जब आपके खिलाफ एक जजमेंट पास हुआ था 27 सितंबर 2020 में. उसके जल्द बाद ही आपने देखा.
योर ऑनर, क्लेमेंट का ये मानना गलत है.
Your Honor, what the claimant is saying is wrong.
Mr. Mehta, you filed a number of witness statements and affidavits in these proceedings, haven't you?
श्री मेहता, आपने गवाहों के बहुत सारे प्रमाण और एफिडेविट लगाए हैं इसमें, है ना?
हाँ, हाँ, ये सही है.
Yes, sir, that is correct.
And all of those statements have been written in English with no reference to you needing help to understand English, written English. Is that correct?
और ये सारे घोषणा जो प्रमाण आपने लिखे हैं, ये सब अंग्रेजी में हैं और आपने इस बात की ये बात का जिक्र नहीं किया है कि आपको लिखित अंग्रेजी में मदद चाहिए, है ना?
ऐसा लिखना कोई जरूरी होता तो लिख लेता.
Had it been necessary to write this, I would have mentioned it.
Would have mentioned what?
आप किस बात की बात करें कि क्या आप मेंशन करते?
मतलब अंग्रेजी वीक है ऐसा लिखने की जरूरत होती तो.
Had it been necessary to mention that my English is not very good.
So do we take it from that, Mr. Mehta, that your witness evidence has been drafted for you and that you haven't had a proper opportunity to verify its truth by having it translated into a language that you understand?
ऐसा है कि जो आपने गवाही दी है वो आप नहीं मिला ये देखने का कि ये सही था या नहीं.
मतलब मैं जो भी अपनी लैंग्वेज में पूरा ड्राफ्ट करता था और उसका किसी से प्रॉपर ट्रांसलेशन करा के और उससे समझ के बाद में ही ये फाइल किया गया है.
I used to draft these statements in my own language and then I used to get them translated, and understanding what the translation was, I filed these statements.
Is that true of your first and second affidavits?
और ये बात आपके पहले और दूसरे एफिडेविट के लिए सही है?
योर ऑनर, सही है.
Your Honor, that is true.
So you'll have no objection to DLA making available copies of the documents, the first and second affidavits in Hindi immediately, will you?
तो आपको इसमें कोई आपत्ति नहीं होगी अगर डीएलए आपके दस्तावेज जो कि पहले और दूसरे एफिडेविट हैं उनका हिंदी में अनुवाद सामने रखे?
नहीं, मतलब डीएलए को ये ट्रांसलेशन तो मैं मेरे इंडिया वाले दोस्त से ही करवाता था, तो उसमें डीएलए को मैंने हिंदी में नहीं भेजा है, मैंने इंग्लिश में ही भेजा हुआ है.
So the translation of these documents was sent by me in English. The translation was gotten done from my behalf, and the DLA didn't need the translation.
You've just changed your evidence, Mr. Mehta, but do you have available to you the Hindi originals of the first and second affidavits so that you're able to send them to my solicitors, my attorneys over the lunch break?
आपने ये जो प्रमाण दिया है ये आपने बदल दिया है, तो क्या आप ये हिंदी का जो अनुवाद है ये आप मेरे सॉलिसिटर्स को भेज सकते हैं जब लंच का ब्रेक होएगा?
योर ऑनर, हिंदी का जो भी लिखा हुआ था वो उस समय लिखा था, और उसके बाद ये ट्रांसलेशन हो गया, तो उसका कोई कॉपी मैंने हिंदी में रखा नहीं है।
Once the translation was done from Hindi to English, I did not keep the Hindi copies with me.
That's very convenient, isn't it, Mr. Mehta?
ये तो आपके लिए काफी convenient हो गया है, श्री मेहता।
योर ऑनर, ये क्या कहना चाहते हैं मेरे को समझ में नहीं आ रहा है।
Your
Can you
Honor,
turn up page? Sorry.
Your Honor, what is being said, I do not understand.
Okay, I'll move on. Can you turn to page 685?
आप क्या 685 पेज नंबर पर जा सकते हैं?
मतलब मेरी कौन सी एफिडेविट का या विटनेस स्टेटमेंट नंबर, मैंने खाली, मेरे पास ये नंबर नहीं है, तो
I do not have this number, so if you could tell me the exact document, is it?
It's on the
witness
screen,
statement?
Mr. Mehta. We'll just scroll down a bit so you can see it more clearly. This is the freezing order. I assume you've seen that
ये
before.
स्क्रीन पर है श्री मेहता, मैं थोड़ा नीचे स्क्रॉल करूंगा, ये फ्रीजिंग ऑर्डर है।
Made by this judge, His Excellency Justice Ali Madhani.
ये जो फ्रीजिंग ऑर्डर है ये माननीय जज श्री अलियर मधानी की तरफ से है।
So look at the bold text headed penal notice. We'll just scroll down so you can see it in full. Did you understand that at the time?
आप ये जो बड़ा बड़ा लिखा हुआ है जो पीनल नोटिस के नीचे लिखा है, क्या आप इसे समझ पा रहे हैं?
आप थोड़ा सा समझा देंगे मेरे को, ताकि मिसअंडरस्टैंडिंग।
The witness is asking the interpreter to explain in Hindi. Is that allowed?
All I'm asking is for him to confirm that he understood what that meant when he saw the freezing.
वो आपसे सिर्फ इतना पूछ रहे हैं कि आप ये समझ पा रहे हैं जो नोटिस में लिखा है।
सीधा जी, अगर आप एक बार इसका ट्रांसलेट करके मेरे को बता देवे तो, ताकि कुछ गलती ना हो।
I'm sorry, I didn't catch any of that. Are you able to repeat what you just said?
Yes. The witness is requesting the interpreter to explain what is written in Hindi.
I don't want to waste time with that. I just want the witness to answer the question as to whether or not he understood that text when he was sent a copy of the freezing order by his lawyers.
मैं इसमें समय जाया नहीं करना चाहता, मैं बस आपसे ये जानना चाहता हूँ कि आपने जो भी यहाँ पे लिखा है वो आप समझ पाए थे जब आपको ये फ्रीजिंग ऑर्डर भेजा गया था?
एक्चुअली जो भी पेपर आते थे तो मैं कोशिश करता था कि किसी से ये सबके ऊपर थोड़ा पूरा समझ लूं। मतलब जितने बहुत सारे पेपर आते थे तो एग्जैक्टली मेरे को मतलब किसका मैंने प्रॉपरली समझा था नहीं समझा था अभी मतलब वो बताना मुश्किल है.
I received lots of documents and papers over the course of this, and it is difficult for me to say what I understood and what I did not understand then.
Mr. Mehta, you were instructing an international law firm that was DIFC qualified when you received this document, and you also instructed an English barrister. Do you recall that?
क्या आपको ये याद है कि आपने एक लॉ फर्म को निर्देश दिए थे जो DIFC द्वारा प्रमाणित है और आपने एक अंग्रेजी बैरिस्टर को भी कुछ निर्देश दिए थे?
किसके बारे में?
What was this about?
They were the lawyers engaged by you at the time you received the freezing order. Do you accept that? Yes or no?
आपने इन्हें कुछ निर्देश दिए थे जब आपको ये फ्रीजिंग ऑर्डर मिला था. क्या आप ये बात मानते हैं?
मतलब किसको निर्देश दिए थे? इसी तरह किसको निर्देश दिए थे? ये मतलब किस कौन सा नाम बताना चाहते हैं? किसको निर्देश दिए थे?
Can you please say who was instructed? Can you give a name, please?
I'm not going to waste time because Mr. Mehta is evading my questions. I'm going to ask instead, please, to turn to page 709.
क्योंकि श्री मेहता जी मेरे सवालों का जवाब नहीं दे रहे हैं, मैं अनुरोध करता हूं कि हम 709 पेज देखें.
We're about to turn up, Mr. Mehta, your first witness statement, which is dated the 12th of December 2020.
ये हम आपका पहला जो गवाही है वो हम देख रहे हैं जो 12 दिसंबर 2020 की है.
Do you have it on your screen, Mr. Mehta?
क्या ये आपके स्क्रीन पर है श्री मेहता?
नहीं, अभी अपलोड नहीं हुआ है मेरे ख्याल से स्क्रीन पे.
No, I think it has not uploaded yet on my screen.
Not yet, Mr. Win, not even mine.
Okay, well, I can ask the question whilst the document is being pulled up. Your first witness statement made express reference to the freezing order, and it purported to address the freezing order. Do you recall that witness statement?
जब तक ये अपलोड हो रहा है मैं अपना सवाल पूछ रहा हूँ. आपने अपने पहले जो आपने गवाही दी थी उसमें आपने फ्रीजिंग ऑर्डर का प्रत्यक्ष रूप से जिक्र किया है और आपने इस फ्रीजिंग ऑर्डर का जवाब भी लिखा है. क्या ये आपको याद है?
And we can now see it at paragraphs 4 and 5.
और आप चौथे और पांचवें पैराग्राफ को देख सकते हैं.
हाँ, देख सकता हूँ.
Yes, I'm seeing the paragraphs.
And we can see in paragraph 4 that, as I put to you earlier, an international law firm, Ashish Mehta and Associates, were the legal representatives for you and Renish. Do you see that?
क्या ये आप देख रहे हैं कि आशीष मेहता एंड एसोसिएट्स ये आपके कानूनी प्रतिनिधित्व आपका कर रहे थे, आपका और रेनिश का?
हाँ, ये बात सही है योर ऑनर।
Yes, that's correct, Your Honor.
And your witness statement would not have addressed the freezing order without you having had the terms of the freezing order fully explained to you. Do you agree?
और आपकी गवाही में आपने इस फ्रीजिंग ऑर्डर का जवाब तब तक नहीं दिया होगा जब तक किसी ने आपको इस फ्रीजिंग ऑर्डर के बारे में अच्छे से बताया नहीं होगा विस्तार रूप से। ये बात सही है?
योर ऑनर, उसमें जो थोड़ा सा मेरे को याद है कि मेरे पास फंड की बहुत ही थोड़ी सी अवेलेबिलिटी थी और मैंने आशीष मेहता एंड कंपनी को ये फ्रॉड क्लेम के लिए किया था और उन लोगों ने उस टाइम ये बताया था कि कुछ फ्रीजिंग ऑर्डर है तो आप अपने हिसाब से देख लो, क्योंकि मैंने उनको पहले उसके लिए एंगेज नहीं किया था। तो उन लोगों ने ऐसा बताया था कि आप ये फ्रीजिंग ऑर्डर है वो देख लो और आपके हिसाब से आप उसमें जो भी विटनेस करना चाहते हो वो करो। मतलब मेरे को प्रॉपरली समझाया नहीं गया था।
As far as I remember, at the time I had some fund availability and I had engaged Ashish Mehta and company in this fraud claim. And in fact, I was not explained very properly about this freezing order then.
Mr. Mehta, could you just confirm whether you are now prepared to waive privilege over all communications that you've had with your legal advisors, or do you want to maintain privilege, which you are entitled to do? And it may be that your counsel will have some observations in relation to that question.
Your Excellency, I would just say, I mean, it's plainly obvious that Mr. Mehta is not going to understand the intricacies of the question Mr. Williams addressed. I leave Mr. Mehta to answer, but what I would say is that it's plainly unfair to put what effectively is a legal question to him on the stand without any obvious. I mean, I don't know where this is going. It's not very clear what he's suggesting he's waiving privilege over, first of all.
Well, it's very clear, Your Excellency, because Mr. Mehta suggested that the terms of the freezing order were not properly explained to him by his lawyers. Now, if he wants to waive privilege, then that is something that will need to be explored. And Mr. Mehta, the position is very simple. It's not an intricate question. You have an absolute entitlement to maintain confidentiality over communications between you and your lawyers. And you do not have to tell me what those communications are. However, if you wish to rely on what your lawyers said or did not say to you, then you have to waive privilege, which means that I am then entitled to explore with you what you have said to your lawyers and what they have said to you over time. Do you understand?
श्री मेहता, आपके पास ये विकल्प है कि जो भी आपकी बातचीत हुई थी, आपके जो लॉयर हैं उनके बीच, आपके और उनके बीच में जो भी संचार हुआ, जो भी आपने इस दस्तावेज पर जो भी बात करी, वो आप हमारे सामने प्रस्तुत ना करें। ये आपके सामने एक विकल्प है और आप ये बोल सकते हैं कि मैं आपसे ये बात साझा नहीं कर सकता, और लेकिन अगर आप मुझसे ये बात साझा करना चाहते हैं कि आपके बीच में क्या बातचीत हुई इस फ्रीजिंग ऑर्डर के टर्म्स के ऊपर, तो इसके ऊपर मैं आपसे कुछ सवाल पूछना चाहूंगा। तो ये आपके ऊपर है कि आपकी जो प्रिविलेज है कि आप अपनी बात साझा करेंगे, आपके और आपके वकीलों के बीच में जो भी बात हुई थी वो आप साझा करेंगे, या फिर आप ये बात हमसे नहीं करना चाहेंगे?
योर ऑनर, ये मेरे ख्याल से लगभग 3 साल पुरानी बात है। तो मतलब मैं ये बताना चाहूंगा कि उस टाइम मेरे पास फंड की काफी कमी थी। लॉ फर्म को खाली फ्रॉड केस के लिए एंगेज किया गया था, और उस टाइम उन लोगों ने ये जो फ्रीजिंग ऑर्डर है वो बताया था, और मेरे को ये बोला था कि वैसे भी विटनेस स्टेटमेंट में कभी वकील हेल्प नहीं कर सकता, आपको खुद ही लिखना है, तो आप अपने हिसाब से उसको देख लो। इस तरह से बात हुई थी।
The interpreter would like to request Mr. Mehta to repeat the last sentence because the connection was lost.
तो
Shri Mehta ji, क्या आप ये
हाँ,
may
मतलब
I ask
हाँ,
Mr. Mehta if with the permission of the court?
Ask him in Hindi, please.
Yes sir, thank you. श्री मेहता जी, क्या आप जो आपने जो बात कही वो आप दोहरा सकते हैं, क्योंकि कनेक्शन में थोड़ी दिक्कत आ गई थी।
हाँ जी। मैंने आशीष मेहता एंड कंपनी को, जो मेरे को याद है, मेरे पास कुछ ही फंड सोर्स हो सकते थे, तो फ्रॉड क्लेम के लिए हायर किया था। और उसके बाद उन्होंने ये फ्रीजिंग ऑर्डर का मेरे को बताया, जो शुरू में उनके स्कोप में तो खाली फ्रॉड क्लेम का ही था, और उन्होंने उस समय ऐसा बोला कि इसके लिए आपको विटनेस स्टेटमेंट फाइल करना है, और लॉ फर्म विटनेस स्टेटमेंट में आपको कुछ हेल्प नहीं कर सकती, तो आप आपके हिसाब से ये विटनेस स्टेटमेंट फाइल करो। तो उनकी तरफ से और कुछ ज्यादा गाइडेंस मेरे को मिला नहीं।
Your Honor, I would like to inform you that I had hired Ashish Mehta and Company to help me file this witness statement against the fraud claim. At that point, I had very limited funds, and whatever the freezing order was, they informed me and they said that this was in the scope of the fraud claim that was mentioned earlier. And they said that you need to file the witness statement, and the law firm cannot guide you in that. And I had no guidance from them when I wrote this witness statement.
I suggest to you, Mr. Mehta, that that is a lie, and you have not exhibited any communications with your lawyers which support that. Mr. Mehta, I'd like the translator to read some words which I'm about to say, and I'd just like you to answer yes or no as to whether or not you understand these words. The first thing I'd like the translator to interpret is that to the best of your ability, you must inform the applicant's solicitors of all the defendant's assets worldwide exceeding $10,000 in value, whether in your name or not, and whether solely or jointly owned, giving the value, location, and details of all such assets.
पहली चीज जो मैं करना चाहूंगा कि जो भी मैं पढ़ूंगा उसमें आप हाँ या ना बताइए। सबसे पहली चीज कि ये जो रिस्पोंडेंट हैं वो अपनी सबसे जो उनकी योग्यता है उनके हिसाब से वो एप्लीकेंट के सॉलिसिटर्स को बताएंगे कि जो भी विश्व भर में एसेट्स हैं जो $10,000 के ऊपर जिनका मूल्य है, और जो वो अकेले या दूसरे लोगों के साथ इनकी जो वो ओन करते हैं, उसकी जो मूल्य है, जो स्थान है, और उसके ऊपर जो भी विस्तृत जानकारी है, वो बताई जाएगी एप्लीकेंट के सॉलिसिटर्स को।
योर ऑनर, ये उस समय की बात है जो मेरे को मतलब पूरा तो याद नहीं है, बट जो समझ में आया था कि जो मैं कोर्ट से माफी चाहता हूँ कि कुछ मेरी उसमें पूरी समझ नहीं थी, और उसकी वजह से जो आज मैं समझ रहा हूँ कि ये सब कैसे फॉर्मेट में कैसे देनी चाहिए, वो मैं उस समय दे नहीं पाया। और एक दूसरी बात ये थी कि ये सब होने की वजह से, जैसे मैंने बताया है, मेरे पास सब कोई रिकॉर्ड था नहीं, और ये बाद में भी मैंने मुश्किल से सब जगह से जो भी बेस्ट मैं कर सकता था इंफॉर्मेशन कलेक्ट करके दी है।
Your Honor, I do not remember completely, and I would like to apologize to the court that at that moment I could not understand what was required of me, and I could not submit the required details in the right format also. And it was very difficult for me at that point to gather all the documents and information and submit them.
I suggest that that is a lie, and I'd like to turn to page 889, back to your first witness statement.
मैं ये कहता हूँ कि ये झूठ है, और हम आगे के पेज की ओर जाएंगे।
And if you scroll down to paragraph 7.
7वें पैराग्राफ में देखें।
And then look at paragraph 8. This is your witness statement, so you should be familiar with it.
ये आपकी गवाही है।
You did not even attempt to identify any assets belonging to you or Renish, did you?
और इसमें आपने लिखा है कि अगर आप ये गवाही देखेंगे तो आपने कोशिश भी नहीं की कि आप अपने या रेनिश के एसेट इसमें बताएं।
योर ऑनर, मैं उस समय जो समझा था कि मेरी सब एसेट कोई ना कोई बैंक के पास गिरवी रखी गई थी।
The interpreter has lost the voice. Can the statement be repeated?
Yes, you did not even attempt to identify your and Renish's assets. And it's a yes or no question.
The interpreter did not receive the audio inputs. Can that last part be repeated, please?
First, can you tell Mr. Mehta that the answer to this question is either yes or no? And my question is that he did not even attempt to identify his and Renish's assets in this witness statement.
इस सवाल का जवाब हाँ या ना में दीजिए कि आपने और रेनिश ने ये कोशिश भी नहीं की कि आप अपने एसेट की पहचान करें।
योर ऑनर, ये गलत है।
Your Honor, that is not true.
And you didn't even attempt to identify what had happened to monies paid into the account belonging to Prime. Yes or no?
और आपने ये भी पता लगाने की कोशिश नहीं की कि जो रकम आपने क्राउन के अकाउंट में भेजी थी उसे क्या हुआ?
योर ऑनर, ये सब होने के बाद मैं एक बहुत ही बुरी मानसिक स्थिति में था और सब जगह से सब चीज भयावही आ रही थी। तो मैं एक ऐसे सदमे में चला गया था कि उसके बाद मैं ये सब चीजों क्या था क्या नहीं वो सब के लिए एक समय के लिए बिल्कुल अलिप्त हो गया था, ये मानसिक सदमे की वजह से।
Your Honor, I was in a bad mental state then, and with everything that was happening, I was quite traumatized and I did not know what was happening.
And do you accept that as this judge has found, you deliberately breached the freezing order?
और क्या ये आप मानते हैं, जैसा कि माननीय जज ने पता लगाया, कि आपने जानबूझकर इस फ्रीजिंग ऑर्डर का उल्लंघन किया?
योर ऑनर, मैं कोर्ट के आदेश का हमेशा सम्मान करता हूँ।
Your Honor, I always respect the court's orders.
This is your first affidavit we're looking at, Mr. Mehta. In paragraph 13, you say that you believed that what you said in your first witness statement was the best you could achieve. That statement is a lie, isn't it?
ये आपका पहला जो गवाही है, उसमें से जो 13वां पैराग्राफ है, उसमें आपने लिखा है कि आप के हिसाब से ये जो भी किया वो आपने जो आप कर सके उस समय, वो आपकी तरफ से सबसे बढ़िया काम था।
इसी तरह जी, आप उसका पूरा एक बार देख के समझा दोगे तो मैं फिर इसका जवाब दे दूं। 13 नंबर क्या है? चलो। ये जो 13वें नंबर का पॉइंट का बात कर रहे हैं, तो एक बार स्क्रीन पे ला सकते हैं और अपने एक बार उसको समझ ले।
The 13th paragraph that you're referring to, maybe please go back to that and may I see it on the screen, please?
Yes, what you say there is that I gave details of my assets. I admit inadequately in HCM1. That's your first witness statement. You go on to say, at the time, I believed that this was the best that I could achieve. That assertion is a lie, Mr. Mehta, isn't it?
आपने इसमें लिखा है कि मैंने अपने एसेट के ऊपर काफी विस्तार से जानकारी दी थी, लेकिन ये पर्याप्त नहीं थी HCM1 में। ये आपका पहला जो आपकी गवाही है उसमें से है, और इसमें आपने ये भी लिखा है कि उस समय आप ये मानते थे कि यही आप उतना ही कर पा रहे थे। ये झूठ है ना श्री मेहता?
क्लेमेंट अपने हिसाब से जो भी सोचे, बट मैंने जो सही था वही लिखा है।
Your Honor, the claimant might think that, but what I found to be true is what I have written.
Now, at paragraph 16, there is a list of property assets You were aware of those assets at the time you signed your first witness statement, weren't you?
16वें पैराग्राफ में एक सूची है जो दर्शाती है कि प्रॉपर्टी एसेट्स कौन से हैं। जब आप अपना पहली गवाही दे रहे थे तो आपको इन एसेट के ऊपर जानकारी थी, है ना?
योर ऑनर, मैं पूरी कोर्ट से माफी के साथ ये बात कहना चाहूंगा कि मेरी एक समझ में फर्क था कि जो एसेट बैंकों को गिरवी रखी गई थी, तो मेरे को ये कभी समझाया नहीं गया था कि वो एसेट भी इसमें मेंशन करनी है, इसमें लिखनी है। तो मैं ये समझ रहा था कि जो चीजें दूसरी बैंकों को गिरवे रखी है और जहां पे मेरा एसेट की कीमत से भी ज्यादा भुगतान बाकी है, तो वो एसेट मेरी नहीं है। ऐसे एक मानसिक स्थिति से मैंने वो सब मेंशन नहीं किया था।
Your Honor, I would like to apologize to the court for the misunderstanding I had that the assets that were kept as collateral with the bank were also to be mentioned. I did not mention those assets which were kept as collateral with various banks and whose repayment was more than the value of the assets.
Mr. Mehta, you were well aware of all of the assets referred to in your first affidavit when you made your first witness statement, but you deliberately failed to mention them. That's correct.
Shri Mehta, आपको अपने सारे एसेट्स पता थे जब आप अपना जब पहली गवाही दे रहे थे, लेकिन आपने उन सब के बारे में उल्लेख नहीं किया, है ना?
योर ऑनर, ये क्लेमेंट का मानना गलत है। जैसे मैंने बताया कि ये जो मेरी समझ थी कि जो मिलकत गिरवी रखी गई है, तो वो मैंने अपना नहीं समझ के उसमें वो लिखा नहीं था।
Your Honor, the claimant is wrong to say that, because according to my understanding, I felt that the assets that were kept as collaterals with the bank were no longer mine, so to speak, which is why I wrote that.
I've pulled up on the screen, Mr. Mehta, your skeleton argument for this hearing. 3 lines from the bottom, it is asserted that it was impossible for you to provide more information in response to paragraphs 9.1 and 9.2 of the freezing order than the information that you provided in your 2 affidavits. This is another yes or no question. That statement is untrue, isn't it?
Your Excellency, I hasten to intervene, but that's my skeleton argument. That's not Mr. Mehta's evidence.
Yeah, I'm still entitled to ask questions about it. And I am putting to Mr. Mehta that the statement that it is impossible for the second defendant to provide more information in response to the freezing order than he has done in his 2 affidavits is an untrue statement. Mr.
That's
Mehta
not his statement, is it, Mr.
Yeah,
Will?
we can't, I mean, turn the question to be his lawyer says this, and then he can confirm or not.
I'm still entitled to ask him whether or not that statement's true. Just
Yeah.
because it's not his evidence, it's neither here nor there. Do
Mr.
you
Will,
accept
Yeah,
that statement is untrue?
question aloud, yes.
मैं आपसे ये सवाल हाँ या ना में पूछना चाह रहा हूँ। आप स्क्रीन में जो नीचे लिखा गया है, अंत की 3 लाइनों में आपने ये लिखा है कि ये आपके लिए नामुमकिन था कि जो भी आपने जानकारी दी है पैराग्राफ 9(1) या और 9(2) के जवाब में, उससे ज्यादा आपके लिए जानकारी देना बिल्कुल मुमकिन नहीं था। आपके एफिडेविट में जो आपने जानकारी दी है उससे ज्यादा, ये आपके हिसाब से ये सही है या नहीं? आप हाँ या ना में जवाब दीजिए।
मतलब मैंने कौन सी एफिडेविट में या विटनेस में लिखा है, कहाँ पे है?
Where have I mentioned this? In which affidavit?
You haven't. It's in your skeleton argument, but a statement is made that it was impossible for you to provide more information than you have done in your 2 affidavits in response to the freezing order. And I'm simply asking you to confirm whether or not that statement is untrue.
ये आपके एफिडेविट में नहीं है, ये आपके जो स्टेटमेंट जो आपकी तरफ से गई है उसमें है। और हम बस आपसे ये पूछ रहे हैं कि ये जो यहाँ पर लिखा है कि आपके लिए नामुमकिन था जानकारी देना, ये सही है या नहीं?
योर ऑनर, मेरे पास जितनी भी जानकारी थी वो मैंने दी, और उससे ज्यादा मेरे से मतलब कुछ भी मेरे पास पॉसिबल नहीं था।
Your Honor, all the information I had was already given, and beyond that, it wasn't possible for me to furnish any more information.
Thank you. Do you accept that your affidavits do not exhibit a single written communication to any bank seeking information about your and Renish's bank accounts?
क्या आप ये बात मानते हैं कि आपके एफिडेविट में एक भी जगह आपने कहीं भी लिखित जानकारी, लिखित संपर्क बैंक से नहीं साझा की है, जिसमें आपने बैंक से अपने अकाउंट और रेमिश के अकाउंट के ऊपर आपने जानकारी ली हो?
योर ऑनर, इसमें जमीनी हकीकत ये थी कि मैं जब ये मानसिक सदमे से धीरे धीरे बाहर आ रहा था तो काफी समय चला गया था, और मेरा ट्रेड लाइसेंस भी रिन्यू नहीं हुआ था, और दूसरा के बैंकों के साथ जो कॉरेस्पॉन्डेंस होता था तो उसका जो ऑथोराइज ईमेल आईडी भी मेरे पास नहीं था। तो मैंने किसी को बैंक में वहां भेज के ये इंफॉर्मेशन निकालने की कोशिश करी थी।
In reality, Your Honor, at the time I was suffering from a mental trauma, and a lot of time had passed, and even my trade license had not been renewed. And the correspondence, as for the correspondence with the bank, I didn't have the authorized email ID. Hence, I sent somebody to the bank to find out the details.
That's nonsense, Mr. Mehta. There is no reason why you or your lawyers could not make a written request from the bank about the status of your and Renish's bank accounts, is there?
ये बात बिल्कुल बकवास है श्री मेहता, क्योंकि ऐसा कोई कारण नहीं था कि आप या आपके जो वकील थे वो बैंक से लिखित रूप में जानकारी मांग नहीं पाते। ये सही है ना? ये झूठ है ना कि आपने उनसे कोई जानकारी नहीं मांगी, जानकारी मांगी?
योर ऑनर, ये क्लेमेंट का मानना गलत है।
What is being said is untrue.
Mr. Will, Mr. Will, if you allow me, I would like to ask him this question. I mean, when he left the country, he did not know that there is a lot of money has to be paid by him in a very short time.
जब आप देश छोड़ के गए थे तो आपको पता था कि आपको बहुत सारा पैसा बहुत कम समय में लौटाना है।
योर ऑनर, मेरा जो भी ये सब बैंकों में लिमिट था वो एक ट्रेड लिमिट था, जो कोई पर्टिकुलर जो इस तरह का जो मैं पार्टी से डील करूं उसके सामने सब बैंकों की तरफ से दिया जाता था। जैसे कि मैंने उदाहरण रूप पे ये मॉरिशस बैंक से डील किया, तो मेरे को जिससे खरीदना था उसको बैंक पेमेंट करती थी, और जिसको मैं बेचता था वहां से वो बैंक में सीधा पेमेंट आता था। तो उसमें मतलब ऐसा कोई मेरे को कभी पैसा बैंकों को चुकाना इस तरह का कोई ये सब लिमिट नहीं था। ये सब ट्रेड फिनेंस लिमिट था, जहां बैंक मेरे सप्लायरों को पेमेंट करती थी और मेरे जो खरीदार थे वो बैंकों को वो पेमेंट भेजता था वापस। तो इस तरह की लिमिट थी, मतलब ऐसा कोई मेरे ऊपर कोई इसके लिए कोई लोन नहीं था इसके अर्थ के।
Your Honor, with the banks, there was a trade, I had a trade limit, and whenever I had a deal with any party, the banks used to do the transfer and acceptance of payments. For example, I had a dealing with the Mauritius bank, and they used to make the transfer to my buyers, and they used to make the transfer to my suppliers. And as for my buyers, they used to send money in the account. All this used to happen through the banks, and I did not have any outstanding loans on myself.
I'm not sure that answers Your Honour's, my Lord's question, but
योर ऑनर, मैं आपको थोड़ा और इससे ठीक से विवरण करना चाहूंगा अगर आपकी इजाजत हो।
Your Honor, I would like to provide more details if you permit me to.
Yes.
जी।
योर ऑनर, जो ट्रेडिंग कंपनियां होती है तो उनको बैंकों से ट्रेड फाइनेंस लिमिट दी जाती है। जो ट्रेड फाइनेंस लिमिट में बैंक कभी जो जिसको लोन दी गई है उसको पेमेंट नहीं करता है, वो उसके सप्लायर को पेमेंट करता है। और हम लोग जो मटेरियल हमारे खरीदार को बेचते हैं तो वो खरीदार सीधा बैंक को वो पेमेंट वापस भेजता है। तो इस तरह की ये सब फैसिलिटियां थी। तो मतलब कोई मेरे ऊपर उसमें कोई ऐसा सीधा बर्डन ज्यादातर केसों में नहीं था कि जिसमें वो पैसा कहीं कंपनी से चुकाना था। वो जो भी खरीदार थे उनसे ही सीधा वो पैसा आना था।
Your Honor, for trading companies, there is a trade finance limit with the banks. So for example, if a loan is sought from the bank, the money is given to the suppliers directly. And as for the buyers, they are responsible for the repayment. And this sort of a facility was available to me, and I had no burden on me in most of the countries in terms of debt. And this is how the system worked.
I want to return, if I may, to the freezing order and what you say in your first affidavit. And in particular, my question is this: you and your solicitors have made no attempt to contact any bank or any third party to obtain relevant information about your assets or about the monies paid into Prime's NBK account. Do you accept that?
मैं फ्रीजिंग ऑर्डर के ऊपर जो आपने पहला एफिडेविट दिया था उसके ऊपर मैं बात करना चाहूंगा कि आपके और आपके जो सॉलिसिटर थे आपने कोशिश नहीं की कि आप अपने एसेट के ऊपर जो भी जरूरी जानकारी थी वो आप दें कि और कि आप किस तरह से प्राइम्स एनवीबी के अकाउंट में आप पैसा भेज रहे थे।
इसी तरह जी आप क्वेश्चन दोबारा एक बार। इसी तरह जी आप क्वेश्चन दोबारा एक बार बताएगी।
The witness requests a repeat of the question, please.
Yeah, neither you nor your solicitors have made any attempt to obtain any relevant information from a bank or any other third party. Do you accept that?
आपने और आपके सॉलिसिटर्स ने तीसरी पार्टी से कोई भी जरूरी जानकारी पाने की कोई कोशिश नहीं की, क्या ये आप बात मानते हैं?
किसके बारे में जानकारी की कोशिश नहीं की?
Your Honor, which relevant information is being referred to?
Information about the defendant's bank accounts and information about monies that have been paid into Prime's NBK account and what's happened to them.
इंफॉर्मेशन जो आप डिफेंडेंट के जो जानकारी थी कि बैंक से उन्हें इस जानकारी की कौन सा पैसा प्राइम एनवीके के अकाउंट में जा रहा है।
योर ऑनर, मेरा एक निवेदन है कि अगर क्लेमेंट एक एक करके क्वेश्चन करे तो मैं कहीं भी कुछ दुविधा में ना हूं।
Your Honor, I have a request. If the claimant can ask questions one by one, then that way I will be able to answer them.
I've asked the same question 3 times. I will invite the court to conclude that you are simply avoiding answering that question, and so I'm going to move on.
मैंने वही सवाल 3 बार पूछा है और
Your Excellency, in fairness to Mr. Mehta, I think the point he was making is there's a compound question there referring to what seems to be both paragraph 9.1 and 9.2 of the freezing order. So it may assist if it is broken down into 2 questions.
But my question was any relevant information, but I'm happy to break it down. So this is the first question, Mr. Mehta, and it's a yes or no answer. The question is, do you accept that neither you nor your solicitors have attempted to obtain information from any bank or any other third party about the defendant's assets?
ये पहला सवाल है श्री मेहता, क्या ये बात आप मानते हैं हाँ या नहीं कि आपके और आपके सॉलिसिटर्स ने बिल्कुल भी कोशिश नहीं की कि आप जानकारी बैंक या किसी और जगह से मांगे?
योर ऑनर, ये क्लेमेंट का मानना गलत है।
Your Honor, that is wrong.
So which banks have you and your solicitors made requests of information from?
तो ऐसे कौन से बैंक थे जहां से आपने आपके सॉलिसिटर्स ने जानकारी पाने की कोशिश की?
योर ऑनर, मैंने जो यूएई में मेरा जो बैंकिंग इंडस्ट्रीज में जो दोस्त थे उनको ही सब बैंक में ज्यादातर बैंकों में पर्सनली भेजा था ये इंफॉर्मेशन निकालने के लिए।
ऑडियो इनपुट।
हाँ योर ऑनर, मैंने ये जानकारी के लिए मेरे एक जानने वाले दोस्त को यूएई में सब बैंकों में पर्सनली भेजा था, ज्यादातर बैंकों में, और मैं ये चीज मानता था कि ये कोई रिटर्न कम्युनिकेशन से इसका कोई मसला हल होने वाला नहीं है। सो इसके लिए मैंने पर्सनली ज्यादातर बैंकों में मेरे जो जानने वाले हैं उनको भेजा था।
Your Honor, I had some contacts in the banking industry and I sought help from a friend who went to most of the banks to seek information. And I believe that written communication would not solve the issue, which is why I used my personal contacts in the banking industry to gain information for me.
I just put to you, Mr. Mehta, that that is a lie. It's the first time you've mentioned that, and there is no reason at all why you and your solicitors could not have written to any banks.
श्री मेहता, मैं कहूँगा कि ये झूठ है और पहली बार आपने ये बात कही है और ऐसा कोई कारण नहीं हो सकता कि आपने और आपके सॉलिसिटर्स ने किसी बैंक को लिखित रूप से अप्रोच नहीं किया।
योर ऑनर, ये बात मैंने अभी जो बताई है वही बिल्कुल सच है कि मैंने कोशिश किया था और किसी को पर्सनली बैंकों में भेज के ये पूरा कोशिश किया गया था, क्योंकि मेरे पास ऑथोराइज ईमेल आईडी नहीं था, तो मैं कोई भी कॉरेस्पॉन्डेंस करूं बैंकों से तो वो लोग, मैं जानता था कि रिप्लाई नहीं दे।
Your Honor, what I have said is the truth, and I did make attempts. I personally made efforts to make sure that we are approaching the banks in person. And I knew that if I were to write to the banks about these matters, uh, I would not have received any replies.
I'll move on. This isn't a question, Mr. Mehta, but it's context to my next question. What I'm showing on screen at the moment is paragraph 56 from the claimant's particulars claim. And what is referred to there is that on the same day as a payment to Prime cleared, Prime made 2 transfers back to Renish. I wonder, interpreter, if you could just read in Hindi
मैं आगे बढ़ूंगा अब ये
what's said
सवाल
at A and B of that paragraph. Sorry, read out loud to Mr. Mehta 56 and A and B.
अब मैं 56वें पैराग्राफ के पॉइंट ए और बी को पढ़ूंगी। उदाहरण के तौर पे ये उसी तारीख की बात है जब तीसरा पेमेंट क्लियर किया गया था प्राइम अकाउंट में। प्राइम में 2 ट्रांसफर किए गए थे, एक 5.6 मिलियन डॉलर का और एक 1.5 मिलियन डॉलर का, जो रेनिश को किए गए थे। और बी पॉइंट में लिखा है कि जो प्राइम भेजा गया था वो 2.8 मिलियन डॉलर का एक एईडी प्राइम अकाउंट में जो एनबीके का था भेजा गया था, लेकिन उसे उस अकाउंट के से बाहर ट्रांसफर कर दिया गया था। The interpreter has read the statements.
I'm grateful. Now, with that context, I'm going to turn to your first affidavit, paragraph 49, which is on page 25.
अब इसके संदर्भ में मैं एफिडेविट में जाऊंगा 25वें पेज पर।
And while it's loading in temperature, if you could just explain, it has loaded. So we can see the heading above paragraph 48, you're addressing paragraph 9.2 of the freezing order. And at paragraph 49, you say, if I had provided this information in October 2020, my and Renish's answer would be that we do not know, but to the best of my knowledge, none of those sums have been transferred to me or Renish. That statement is untrue, isn't it?
अब मैं उन पैराग्राफ की ओर जाऊंगा जो फ्रीजिंग ऑर्डर के बारे में बात कर रहे हैं। अगर मैं 49वें पैराग्राफ को पढूं तो आपने ये लिखा है, अगर ये जानकारी मैंने अक्टूबर 2020 में दी होती, मेरा और रेनिश का ये जवाब होता कि हमें नहीं पता, लेकिन हमारी जानकारी के मुताबिक इनमें से कोई भी जो पैसे हैं, जो सम हैं, वो हमें वो मुझे या रेनिश को ट्रांसफर नहीं हुए थे।
योर ऑनर,
और
सभी
ये जो लिखा है ये झूठ है।
सॉरी सीता जी, एक बार दोबारा क्या प्रश्न क्या है एग्जैक्टली, आप एक बार बताएंगे?
प्रश्न, the witness is asking me to repeat and I am just repeating the last bit. प्रश्न ये है कि ये जो सवाल है ये सही, ये झूठ है ना? ये जो भी आपने यहाँ पर लिखा है ये झूठ है।
योर ऑनर, ये सही है जो मैंने लिखा है।
Your Honor, what I have written is true.
That is true, is it? So just to confirm, Mr. Renish, your honest evidence is that to the best of your knowledge, none of the sums paid into Prime's NBK account have been transferred to you or to Renish.
और ये आपकी जानकारी के हिसाब से सही है कि जो भी पैसे थे जो प्राइम एनवीके के अकाउंट में से आए थे वो आपको और रेनिश को ट्रांसफर नहीं हुए थे।
योर ऑनर, जो भी हमारा बायर होता है, जो भी हमसे खरीदता है मटेरियल, तो वो हमको जो पेमेंट ट्रांसफर करता है, तो उसमें तो कुछ गलत बात है नहीं।
Your Honor, anything that our buyer gets from us, the material, there's nothing wrong with the payment transfer made in lieu of that.
Right, so you've changed your evidence, Mr. Mehta, because your first answer was that the statement in paragraph 49 was true. You're now moving to a position of saying that it's not entirely true. Is that correct?
आप अपना प्रमाण बदल रहे हैं। पहले आपने कहा कि जो 49वां पैराग्राफ है वो सही है और अब आप बोल रहे हैं कि ये पूरी तरह से सही नहीं है ना श्री मेहता जी?
योर ऑनर, मेरे को उनका जो प्रश्न है वो समझ में नहीं आ रहा है कि वो क्या पूछना चाहते हैं।
Your Honor, I do not understand their question, what they are trying to ask.
I'll give you one last chance, Mr. Mehta. In paragraph 49, you state that to the best of your knowledge, none of those sums that have been transferred, none of those sums paid to Prime's account have been transferred to me or to Renish. That statement is untrue.
मैं आपको एक आखिरी चांस देना चाहूंगा। आपने 49वें पैराग्राफ में ये लिखा है कि आपकी जानकारी के मुताबिक जो भी ये पैसे थे वो आपके और रेनिश के अकाउंट में नहीं आए थे, आपको ट्रांसफर नहीं किए गए थे। तो ये गलत है ना?
योर ऑनर, मेरा जो कहने का मतलब है यहाँ पे कि जो नॉर्मल कोर्स ऑफ बिजनेस में जो भी पेमेंट आते रहते हैं वो एक ट्रेडिंग एक्टिविटी के तहत आते हैं, तो वो कोई कंपनी की एसेट नहीं है, वो एक ट्रांजैक्शन के रूप में आए हुए हैं पैसे कि हमने जो मटेरियल बेचा है उसका पैसा आया है।
Your Honor, this is the amount received in the normal course. We receive amounts in the normal course of business, which is part of the trading activity. They're not part of company asset, but they form part of the business transaction.
So, Mr. Mehta, the statement that none of those sums have been transferred to Renish is untrue. Yes, it is. That's right, isn't it?
तो यहाँ पर कि इसमें से जो भी सम है वो आपके पास नहीं आए हैं, ये झूठ है ना?
योर ऑनर, यहाँ कहने का मतलब ये है कि उसमें से मतलब जो प्राइम ने हमको पेमेंट किया है वो नॉर्मल कोर्स ऑफ बिजनेस में उसने हमसे जो मटेरियल खरीदा है जो उसके बारे में किया गया पेमेंट है। और मेरे ख्याल से क्लेमेंट कुछ उसको बात को उल्टाना चाहते हैं।
Your Honor, what I want to say is that this is the money received in the normal course of business for the material that was bought. And I think the claimant is sort of falsifying this.
And you have given no information or documentation in relation to what the course of business you're referring to is, correct?
और आपने कोई भी दस्तावेज या जानकारी नहीं दी है कि ये नॉर्मल कोर्स ऑफ बिजनेस क्या है ना?
योर ऑनर, ये हमारा और मतलब प्राइम और दूसरी कंपनियों के साथ दो तरफा व्यवहार हमेशा चलता रहता है। और जैसा था कि मेरे पास डॉक्यूमेंट और रिकॉर्ड्स अवेलेबल नहीं है, बट मैं जो समझ रहा हूं कि प्राइम ने भी अपने विटनेस स्टेटमेंट में ये चीज कंफर्म करी है कि ये पेमेंट उसने हमारे सप्लाई के सामने दिया है।
Your Honor, we have two-way business with Prime and other companies, and as I said earlier, I do not have documents and records around this, but Prime's witness statement also says the same thing.
You knew at the time, Mr. Mehta, that Renish had received several $1 million from Prime's account, didn't you?
आपको उस समय पता था कि रेनिश को प्राइम के अकाउंट से कई मिलियन डॉलर मिले थे, है ना?
योर ऑनर, हम जिसको भी सप्लाई देते हैं तो उससे पेमेंट आता रहता है, तो ये क्लेमेंट जिस तरह से ये बात को रख रहे हैं ऐसा कुछ नहीं है।
Your Honor, whoever we supply the material to, we receive payments from there. And the way this question is being asked is not a reflection, not a correct reflection.
Well, he's not in a position to comment on the questions. I mean, he just answer. Tell him that.
आपको उत्तर देना है जो सवाल पूछा गया है उसका।
जी योर ऑनर।
Yes, Your Honor.
No, let him answer.
आप जवाब दीजिए।
योर ऑनर, मेरा कहना यही है कि प्राइम से या और भी सब पार्टियों से हमारे सप्लाई के सामने पेमेंट आते रहते हैं, और यहाँ जो पेमेंट जिक्र कर रहे हैं, तो प्राइम से जो भी पेमेंट आए हैं वो एक जेन्युइन ट्रेड के सामने आए हुए पेमेंट है। यही मेरा कहना है।
But he says,
The interpreter lost Mr. Mehta towards the last part of the sentence.
मैं
Listen to
दोबारा
him.
रिपीट।
क्या आप फिर से
हाँ।
बोल सकते हैं जो अंत में आपने
बिल्कुल।
कहा?
योर ऑनर, प्राइम और दूसरी पार्टियों से जो भी हमने सप्लाई दिया है उसके तहत पेमेंट आते रहते हैं, और उसमें कोई आश्चर्य की बात नहीं है। और ऐसे हम लोग बिलियंस के ट्रांजैक्शन करते थे, तो अभी की जो बात प्रोसीडिंग चल रही है उसमें मेरे पास जो भी रिकॉर्ड तो है नहीं, बट ये तरह के ट्रांजैक्शन की बात उठा के कुछ मतलब नहीं है।
Your Honor, we keep receiving payments for supplies to Prime and other companies, and we keep having transactions in billions of dollars. And as for the proceedings at hand, I do not have the records, but raising this is not, it will not lead anywhere.
So your evidence is it, Mr. Mehta, is that you haven't bothered to provide any information about the trading activities relating to this sum?
तो आपके प्रमाण में आप ये कह रहे हैं कि आपने अपनी ट्रेडिंग एक्टिविटीज के बारे में कोई जानकारी नहीं दी है।
योर ऑनर, जैसे मैंने पहले ही बताया कि ये सब सिचुएशन की वजह से मेरे पास रिकॉर्ड नहीं है, और मेरे पास रिकॉर्ड होते तो वो मुझे ही मदद रूप होने वाले थे, तो मैं जरूर से वो प्रमाणित करता। बट ये दुखदायी स्थिति है मेरी कि मेरे पास रिकॉर्ड अवेलेबल नहीं है।
Your Honor, because of the situation, I do not have the records, and these records would have proven helpful to me, but I do not have them available at the moment.
Could you turn to page 24, please?
The interpreter did not receive audio input in case something was said.
Doesn't matter, we were just turning up the page.
हम अब 24वां पेज देखेंगे।
This is your first affidavit.
ये आपका
If
पहला
I could just
एफिडेविट है।
scroll up to see there's a table of bank accounts.
यहाँ
then
पर
if you
आप
scroll
बैंक
back
अकाउंट एक
down
टेबल देख रहे हैं, और
to
अगर हम नीचे
42.
जाएंगे तो 42वें नंबर पे
You say at paragraph 42, I have no way of checking this definitively, but I am convinced that all of the above two accounts will have nil balances.
आपने ये कहा है कि मेरे पास ये इसकी पुष्टि करने की का कोई तरीका नहीं है, लेकिन मैं यकीन से कह सकता हूँ कि सारे जो अकाउंट हैं, इनमें से जो ऊपर के जो 2 अकाउंट हैं उनको छोड़कर सब में कोई भी बैलेंस नहीं होगा।
You haven't even bothered to make inquiries which would enable the definitive position to be established. Do you agree?
क्या आप ये बात मानते हैं कि आपने जानकारी इकट्ठा करने की बिल्कुल भी कोशिश ही नहीं की जिससे हमें ये पता चल जाए, है ना?
योर ऑनर, ये बात गलत है। मैंने जैसे पहले भी बताया कि मैंने जानकारी इकट्ठी करने की कोशिश की थी, बट मिल नहीं पाई थी जानकारी। और सब अकाउंट यूएई में ही है। अभी भी वो लोग चेक करवा सकते हैं कि क्या पोजीशन है एक्चुअल में।
Your Honor, this is wrong. I tried to get information, but unfortunately, I could not find any information. And all accounts are in UAE, and this information can be verified there.
If you haven't exhibited a single email or letter, either from you or your solicitors or anyone else, making contact with these banks, have you?
आपने कोई भी पत्र या ईमेल हमें नहीं दिया है कि आपने या अपने वकीलों से इन बैंकों से बात करने की कोशिश की, इनसे जानकारी लेने की कोशिश की।
योर ऑनर, ये प्रश्न बार बार जो आ रहा है, तो मैं इसके ऊपर पूरा विवरण दे रहा हूँ। जैसे मैंने बताया कि बैंकों
Your
के साथ
Honor,
हम
I'm trying my best to answer the question that is being asked to me repeatedly.
ये कोई भी बैंक में क्लेमेंट भी जानते होंगे कि बैंक जो ऑथोराइज ईमेल आईडी है उसके साथ ही कॉरेस्पॉन्डेंस करता है, उसको छोड़ के और कोई कॉरेस्पॉन्डेंस वो लोग जवाब देते नहीं है। दूसरा, मेरे को ये भी समझ में था कि बैंकों को जो केवाईसी डॉक्यूमेंट हर साल देने पड़ते थे, जिसमें मेरे ट्रेड लाइसेंस की कॉपी और बहुत सारे डॉक्यूमेंट, जो ये सब परिस्थिति की वजह से मैं दे नहीं पाया हूं। और ये सब सिचुएशन देख के इसका सही जो इलाज था, मतलब जो पॉसिबल हो सकता था कि किसी को पर्सनली बेच के रिक्वेस्ट करके ये डिटेल निकाली जाए, जो मैंने कोशिश करी थी। बट वो कोई सब बैंकों से जो रिप्लाई आ रहा था कि सब बैंक के स्टाफ मेरे अकाउंट की कोई भी इंफॉर्मेशन देने से डरते थे, और कुछ लोगों ने ऐसा भी बताया कि ये हायर मैनेजमेंट ने आपका अकाउंट सीज कर दिया है, तो आप हम भी देख नहीं सकते इंफॉर्मेशन और दे भी नहीं सकते। तो इस तरह की एक भयावह सिचुएशन थी।
Your Honor, I would like to state that the correspondence any correspondence that I would have attempted, I would not have received answers to the written correspondence. And every year I have to do KYC with the bank. With that, I have to attach my trade license. And because of the situation, I could not give it. And because of this situation, I knew that written communication would not work. Hence, I tried personally sending someone to go and request the details of the bank, details from the bank. I tried my best, and every time the reply I received was that the staff were extremely hesitant to provide information because the high management had frozen all my accounts, and they said that they would not be able to give any information, and this was the terrible situation that I found myself in.
Mr. Weir, I would like to remind you of the time. You still have half an hour with the witness.
Yes. Thank you. I just want to ask the witness fairly, so I put my case to him that you have deliberately failed to produce information about your assets that is available to you, Mr. Mehta. Do you accept that, yes or no?
आप हाँ या ना में ये बात बताइए कि आप मानते हैं कि जानबूझकर आप अपने एसेट के बारे में जानकारी देने में असफल हुए?
योर ऑनर, क्लेमेंट का ये मानना गलत है। मैंने जानबूझ के ऐसा कोई कोशिश नहीं किया है।
Your Honor, this is wrong, what the claimant is saying. I never tried to do something like this deliberately.
And you have failed to provide any documents relating to the status of the property assets that you refer to in your affidavit as well. Do you accept that?
और आपने अपने प्रॉपर्टी एसेट के ऊपर भी जानकारी नहीं दी है जिनका जिक्र आपने अपनी गवाही में किया है। ये बात आप मानते हैं कि आपने इसके ऊपर जानकारी नहीं दी है?
योर ऑनर, ये बात सही है कि रिकॉर्ड ना होने की वजह से मैं और कोई ज्यादा डिटेल प्रोवाइड नहीं कर पाया हूँ।
Your Honor, that is true that I was not able to give information because I had no records.
And you've made no attempt to obtain such records?
और आपने कोशिश भी नहीं की कि आप रिकॉर्ड्स पाने की कोशिश करें?
योर ऑनर, मतलब पेमेंट किस तरह का, मतलब उनका प्रश्न कुछ सही तरीके से पूछे तो मेरे समझ सकता हूँ।
Your Honor, if the question is put to me more appropriately, I will be able to understand it better.
I'll move on, Mr. Mehta, and we'll invite the court to draw the obvious inference. I'm going to turn now to
मैं
page
आगे बढ़ूंगा मिस्टर
23.
मेहता, और जो कोर्ट हैं वो इस बात को समझेंगे।
Now it's the bottom of this page. You say that there may be businesses. Sorry, bottom of 21. I'm sorry. Paragraph 37.8, you say there may be businesses which owe Renish significant sums, and then over the page, there's a reference to Prime Energy owing Renish as much as 137 million dirhams. You say that may be the case. However, I have no records in my possession which I could use to prove that, nor does Renish have any resources or even a valid trade license to pursue Prime Energy. That statement is misleading, isn't it, Mr. Mehta?
इधर आपने जो 37.8 जो पैराग्राफ है उसमें लिखा है कि ऐसे कई व्यापार हैं जिनका जो कर्ज में है श्री रेनिश के, उन्हें काफी पैसा देना है। और यहाँ पर आपने ये भी लिखा है कि प्राइम एनर्जी जो है वो रेनिश को 137 मिलियन दिरहम भी उनका ऋण है। तो और आपने ये भी लिखा है कि मेरे पास ऐसे कोई रिकॉर्ड्स नहीं है जो इसको प्रमाणित कर सकें, और रेनिश के पास भी कोई ऐसे संसाधन नहीं है कि वो प्राइम एनर्जी को इसके लिए जिम्मेदार ठहरा पाए। और ये जो आपने लिखा है ये गलत है ना?
योर ऑनर, ये बात सही है कि मेरे पास जो एक लॉयर को चाहिए केस को प्रूव करने के लिए जितने डॉक्यूमेंट, तो इस तरह के डॉक्यूमेंट नहीं है। और ये बात मैंने जो लिखी है वो उस समय में बिल्कुल सही थी कि मैं बहुत ही कठिन परिस्थिति का सामना कर रहा था प्राइम के ऊपर केस आगे चलाने के लिए।
Your Honor, it is true that I do not have all the documents that a lawyer would require to prove the case, and whatever I have written at the time, it was true that I was facing very difficult circumstances, and I did not have the documents to proceed with the case against the crime with Prime.
The question was whether this statement is a misleading one.
And the statement is that you have no records in your possession which you could use.
और ये जो आपने लिखा है वो ये है कि आपके पास ऐसे कोई रिकॉर्ड नहीं है जिनका आप इस्तेमाल कर सकते हैं।
योर ऑनर, ये जब विटनेस स्टेटमेंट हम लोग लिखते हैं तो उसमें लॉ फर्म हेल्प करने से मना करती है। तो एक लेमैन, एक नॉर्मल आदमी का जो लिखना होता है तो उसकी वजह से हाँ शायद एक लॉयर के जो दृष्टिकोण से उसमें गलती हो सकती है। तो मेरा कहने का मतलब यही था कि उस टाइम मेरे पास रिसोर्सेस की भी कमी थी और जो लॉयर को जितने डॉक्यूमेंट के केस के लिए मेरे से मांग रहे थे वो मेरे पास थे नहीं। मेरे पास जो भी ये DIFC में डॉक्यूमेंट थे कोर्ट के पोर्टल पे वही से काम चलाना पड़ा।
So a law firm refuses to provide any guidance when a witness statement is being written. As a normal man, I could write whatever I understood at the moment, and it obviously will not have that finesse that a lawyer will have, and there may be some misunderstanding. And it is true that I did not have the resources to pursue this at the time, and any documents that I could provide, I tried my best to do so.
Mr. Mehta, your witness statement is dated, or your affidavit was dated November 2021, just 5 weeks before that affidavit we've looked at. You filed a statement of claim in the Sharjah court, didn't you?
श्री मेहता, आपका जो गवाही है वो नवंबर 2021 की है। ये 5 हफ्ते पहले की है जब आपने एफिडेविट दिया था, तो ये ऐसा सही है?
योर ऑनर, क्लेमेंट जिस तरह से ये प्रश्न उठा रहे हैं तो मैं उसका सही विवरण देना चाहूंगा। जो मेरा कहने का मतलब है वो वही है कि शारजा कोर्ट में प्राइम के अगेंस्ट प्रोसीडिंग के लिए मैंने केस फाइल किया था और वो मैंने अक्टूबर में कोर्ट को बताया भी है मेरे स्केलेटन आर्गुमेंट में। वो एक है बात। तो मैंने कोर्ट से कोई बात छुपाई नहीं है। यहाँ मेरा कहने का जो मतलब है वो वही है कि वो केस फाइल होने के बाद जो लोकल लॉ फर्म है उनसे मेरे से डॉक्यूमेंट और ज्यादा मांगे गए थे और दूसरा कि मेरे पास फंड की भी प्रॉब्लम थी कि जिसकी वजह से जिसको मैंने बाद में उनको सक्सेशन बेसिस पे फाइनल करवाया जो थोड़ा पहले लोकल लॉ फर्म हेजिटेंट था। तो ये सब जो परिस्थितियां थी उसका मैंने उसमें जिक्र किया है कि मैं काफी प्रॉब्लम फेस कर रहा हूं इसको आगे बढ़ाने के लिए।
Your Honor, I would like to give certain clarifications on the question that is being asked by the claimant. It's true that I had filed the case against, there were proceedings happening against Prime And as I said in October in my skeleton argument as well, I have not hidden anything from the court. And even after the case was filed, there was a local law firm involved, and I gave all the statements and documents that were necessary. And it is true that I was facing a problem with funds as well. And there was, we proceeded on the basis, on succession basis. And that is how this was finalized, and this has been mentioned earlier as well.
Mr. Mehta, I just want a yes or no answer to this question. Can you make that clear to Mr. Mehta? To the question I'm about to ask. Did you hear that?
I think you should put the question again in simple way, Mr. William.
Okay, but my question is this. Your affidavit gave the clear impression that no proceedings had been brought against Prime and that you were unable to bring proceedings against Prime. But in fact, just 5 weeks before your affidavit, you had brought those proceedings. That's correct, isn't it?
मेरा सवाल ये है कि आपने अपने एफिडेविट में लिखा है कि आपने प्राइम के खिलाफ कोई कार्रवाई शुरू नहीं की और आप इसके खिलाफ कार्रवाई नहीं कर पा रहे थे, लेकिन इससे 5 हफ्ता पहले ही आपने ये कार्रवाई शुरू की। ये सही है?
योर ऑनर, ये प्रश्न को मैं एक एक करके रिप्लाई करना चाहूंगा। नंबर 1, ये जो क्लेमेंट कह रहे हैं कि मैंने जो एफिडेविट में कहा और फाइल किया था, तो मैंने अक्टूबर में मेरे स्केलेटन आर्गुमेंट में कोर्ट को बताया है, जो क्लेमेंट भी उससे क्लेमेंट को पूरी जानकारी है कि मैंने प्राइम के सामने केस फाइल किया है। सो वो मैंने अक्टूबर में ही पूरा बताया हुआ है। तो क्लेमेंट का ये कहना गलत है कि मैंने बताया नहीं है। मैंने अक्टूबर में ही ये चीज कोर्ट के सामने रखी हुई है। दूसरा, ये यहाँ पे एफिडेविट में मेरा जो कहना है, मैं तहे दिल से कोर्ट से माफी चाहता हूं अगर मैं उसको सही तरह से बता नहीं पाया और उसका कोई और मतलब निकल रहा है। जो यहाँ मेरा कहने का मतलब था वो वही था कि वो केस को आगे बढ़ाने के लिए पूरे डॉक्यूमेंट न होने की वजह से और पेमेंट लॉ फर्म को करने की थोड़ी जो भी प्रश्न रहे थे उसकी वजह से आगे बढ़ाने के लिए मैं वहां प्रॉब्लम फेस कर रहा हूं। तो ये मेरा कहना था। अगर उसका कुछ और मतलब निकलता है तो मैं कोर्ट से माफी चाहता हूं कि वो मेरा कहने का मतलब यही था, वो मैं कहना चाहूंगा।
May the interpreter request Mr. Mehta to, with permission of the court, to repeat the second point, please.
दूसरा, ये जो मैंने एफिडेविट में लिखा है तो एक कॉमन मैन की तरह मैंने जो लिखी है, तो मेरा कहने का उसमें जो मैं जो कहना चाहता था वो वही था कि वो केस को प्राइम के सामने आगे बढ़ाने के लिए, जैसे मेरे पास जो लॉयर लॉ फर्म जितने डॉक्यूमेंट मांग रही थी वो सब पूरे थे नहीं, और वो लॉ फर्म को पेमेंट करने के लिए भी रिसोर्सेज की कमी थी। वो बात मैंने यहाँ पे कही गई है। बट अगर उसका कुछ और मतलब निकलता है तो मैं कोर्ट से माफी चाहता हूँ।
I would like to answer this question one by one. The first thing is that what the claimant is saying is not true, and I have written this in my affidavit and while filing it. This skeleton argument was done in October, and the claimant also knows that, and I have mentioned this in October, that proceedings were taking place against Prime. This I mentioned in front of court in October. The second point is I would like to apologize if this has not been clear. Uh, the documents that were being asked by the law firm, they were not all the documents were not available. And this is something that I have written, and I have also mentioned that I did not have the resources, all the resources to pay the law firm. And this is what I have mentioned here. And if another meaning, if something else is coming out of this, I apologize for that.
Mr. Mehta, what's your current residential address in India?
So the interpreter has not received audio input.
What is your current residential address in India?
Sir?
Can you hear me?
Yes, yes, sir. I can hear it now. The interpreter had not received any audio input, I'm afraid.
Question is this. What is your current residential address in India?
आपका भारत में पता क्या है जहां पर आप रह रहे हैं?
45 शिवालिक बंगलो, जो मेरे पासपोर्ट में लिखा गया है वही मेरा एड्रेस है.
It is 45 Shivalik Bungalow. It is the same address that is mentioned in my passport.
How long have you lived there?
आप वहां पर कितने समय से रह रहे हैं?
अंदाजित 20 साल हो गए होंगे.
It's approximately 20 years.
So it's a property that belongs to you, correct?
और ये आपकी खुद की प्रॉपर्टी है ना?
ये गलत है, योर ऑनर.
No, that's not right, Your Honor.
Mr. Mehta, if you've lived there for the last 20 years, do you accept that it is treated as your property?
श्री मेहता, अगर आप पिछले 20 साल से वहां पर रह रहे हैं, तो ये मान सकते हैं कि ये आप ही की प्रॉपर्टी है?
योर ऑनर, ये उनकी मानना गलत है.
Your Honor, that saying that would be wrong.
There's no prospect of you ever being evicted from that property, is there? The question was, there is no prospect of Mr. Mehta being evicted from that property.
कोई ऐसी स्थिति नहीं आई जिसमें आपको इस प्रॉपर्टी से निकाला गया हो?
मैं उनका प्रश्न समझ नहीं पाया, जो क्या पूछना चाहते. ये प्रश्न मेरे को समझ में नहीं आया, क्या पूछना चाहते हैं.
The witness did not understand the question. He wishes to know what is being asked.
There is no possibility of him being forced to leave that property, is there?
Sorry, can the question be repeated for the interpreter, please?
There is no possibility of him being forced to leave that property?
ऐसी कोई संभावना है कि आपको इस प्रॉपर्टी को छोड़ने के लिए विवश होना पड़े?
योर ऑनर, ये बिल्कुल हो सकता है।
Your Honor, it is possible that I may be asked to leave the property.
Who by?
और आपको ये प्रॉपर्टी छोड़ने के लिए कौन कहेंगे?
जो प्रॉपर्टी के ऑनर है वही कह सकते हैं।
Did you get his answer? Could you repeat your answer? Could you repeat the answer, please?
क्या आप फिर से अपना जवाब दे सकते हैं?
हाँ, ये प्रॉपर्टी छोड़ने के लिए जो ऑनर है वो मेरे को बोल सकते हैं।
Yes, I may be asked to leave the property, Your Honor.
By who?
लेकिन आपको कौन बोलेंगे कि आपको ये छोड़नी है प्रॉपर्टी?
जो प्रॉपर्टी का ऑनर है वो बोल सकता है।
The property owner may ask me to leave.
Who is the property owner?
इस प्रॉपर्टी को के ओनर कौन है?
योर ऑनर, मैं इतना कहना चाहूंगा कि ये प्रॉपर्टी का ऑनर मैं नहीं हूँ।
Your Honor, I would just like to state that I am not the property owner.
That's not my question. Who is the property owner?
लेकिन ये सवाल नहीं है। सवाल ये है कि प्रॉपर्टी ओनर कौन है?
मैं ऑनरेबल योर ऑनर से पूछना चाहूंगा कि ये सवाल जो पूछा गया है सही है?
I would like to ask Your Honor if this question being asked is correct.
Yes, you may answer.
जी हाँ, आप जवाब दे सकते हैं।
हाँ, ये प्रॉपर्टी की ऑनर है जिग्ना मेहता, जो मेरी वाइफ है।
इस प्रॉपर्टी की ओनर, the owner of this property is Jigna Mehta, my wife.
And she holds that property for your benefit, doesn't she?
और ये प्रॉपर्टी उनके नाम पर है।
यस ऑनर, ये उनके द्वारा ही खरीदी गई है और उनके नाम पे है।
Yes, Your Honor, she was the one who bought the property and it is in her name.
And she holds it for your benefit.
लेकिन आपकी तरफ से ये प्रॉपर्टी वो देख रही हैं।
योर ऑनर, ये क्लेमेंट किस तरह के क्वेश्चन पूछ रहे हैं?
Your Honor, what kind of questions is the claimant asking?
Oh, the question is, you are the true owner of the property, not your wife.
मैं इसका ऑनर नहीं हूँ, मेरी वाइफ उसकी ऑनर है और यही सत्य है।
I am not the owner of the property. It is my wife who is the owner, and that is the truth.
Does she hold the property for him in trust?
क्या ये प्रॉपर्टी आपके लिए वो ट्रस्ट में रख रही हैं?
नहीं, योर ऑनर, ऐसा कुछ नहीं।
No, sir, that is not correct.
There is no prospect of your wife evicting you from your family home, is there, Mr. Mehta?
श्री मेहता, ऐसी कोई संभावना नहीं है कि आपकी जो पत्नी है वो आपको आपके परिवार के घर से ही निकाल दें, है ना?
योर ऑनर, ये प्रॉपर्टी पत्नी की है तो वो कभी भी मेरे को निकाल सकती है। ये क्लेमेंट किस तरह की बात
Your
कर रहे हैं
Honor,
समझ
the
में नहीं आ
property
रहा है।
is my wife's and
Interpreter, please repeat.
Sorry.
Interpreter, I haven't heard you.
Your Honor, it is my wife's property and she can evict me anytime.
Maybe Mr. Weed, you can ask on what basis.
It's. I think I probably got as far as I can on this, but I would ask you this, Mr. Mehta. Please, can you tell the court your wife's full name?
श्री मेहता, क्या आप कोर्ट को अपनी पत्नी का पूरा नाम बता सकते हैं?
Your Honor, Jigna Mehta.
Your Honor, Jigna Mehta.
How do you spell that?
आप इसको कैसे लिखते हैं?
Your Honor, ये सब चीजों में मैं रिप्लाई करना नहीं चाहूँगा.
Your Honor, I do not want to reply to this.
So you're refusing to provide information in relation to the property that you've occupied for the last 20 years, Mr. Mehta?
क्या आप प्रॉपर्टी जो 20 साल से आप जिस प्रॉपर्टी में रह रहे हैं उसके ऊपर जानकारी देने से मना कर रहे हैं, श्री मेहता?
Your Honor, मैंने पूरी जानकारी दी है. अभी जो क्लेमेंट की तरफ से जो प्रश्न पूछे जा रहे हैं वो मेरे को सही नहीं लग रहे हैं कि स्पेलिंग वगैरह ये सब पूछना वो कोई मायने नहीं रखता है.
Your Honor, I have provided full information. I do not find the claimant's questions to be appropriate, asking spelling, etc.
Okay, Mr. Mehta, I'll move on. Can you tell the court which bank accounts you use to meet your outgoings?
मैं आगे बढ़ता हूँ. क्या आप बता सकते हैं आप किन बैंक अकाउंट का इस्तेमाल कर रहे हैं आपके जो भी आउटगोइंग हैं उनको मैनेज करने के लिए?
Your Honor, मेरे पास अभी कोई बैंक अकाउंट नहीं है और मैं मेरे फैमिली मेंबर के ऊपर ही पूरा रिलाय हूँ मेरे डेली एक्सपेंस के लिए और वो पैसा वो लोग मेरे को कैश में ही दे रहे हैं और मैं उसी से मेरा जो पर्सनल थोड़ा बहुत जो भी एक्सपेंस होता है वो उसी से गुजारा करता हूँ.
My family members are helping me meet my daily expense. They give me cash and this is how I manage my personal expenses.
Which family members?
किन परिवार के सदस्यों की आप बात कर रहे हैं?
Your Honor, ये मेरे फैमिली मेंबर की ज्यादा पर्सनल डिटेल्स और ये सब मैं देना नहीं चाहूँगा.
Your Honor, I would not wish to provide the personal details of my family members.
Mr. Mehta, I think I can wrap up now. I'm just going to put my case to you, which is that you are still deliberately failing to provide information about your assets to the court. Do you accept that?
Mr. Mehta, अब मैं समाप्ति करने वाला हूँ. मैं बस आपसे ये जानना चाहूँगा कि आप जानबूझकर अपने एसेट के ऊपर जानकारी हमें नहीं दे रहे हैं.
Your Honor, क्लेमेंट का ये मानना गलत है. मैंने मेरे पास जो भी जितनी भी जानकारी थी या मैं जुटा सकता था सब मैंने क्लेमेंट को दी है और ये क्लेमेंट का मानना एक खाली एक गलत इल्जाम है मेरे पर और ये वास्तविकता नहीं है.
Your Honor, what the claimant is saying is wrong, and all the information that I have and I could gather, I have provided to the court, and this is a wrong accusation from the claimant's side and not true at all.
And you deliberately failed to provide full information about what became of the monies paid into Prime's bank account.
और आप जानबूझकर हमें पूरी जानकारी नहीं दे रहे हैं कि उस पैसे का क्या हुआ जो प्राइम के अकाउंट से आया था।
योर ऑनर, मैंने जो भी है जानकारी ऑलरेडी दे चुका हूँ कि प्राइम के अकाउंट से जो रेनिस में पैसा आया है वो एक लेजिटिमेट ट्रेड के तहत आया है और रेनिस से उन लोगों ने जो भी सप्लाई दिया था उसी का वो पेमेंट है। यही मेरा पहले भी कहना था और अभी भी यही कहना है। और ये चीज प्राइम ने अपने विटनेस स्टेटमेंट में भी कंफर्म करी है। और सबसे अहमियत वाली बात ये है कि योर ऑनर के जब भी एक बैंक पेमेंट प्रोसेस करती है कि जैसे वो प्राइम की बैंक ने वो पेमेंट प्रोसेस किया, तो पेमेंट प्रोसेस करने से पहले पूरे सब डॉक्यूमेंट ट्रेड रिलेटेड बैंक लेके उसके बाद ही वो पैसा ट्रांसफर करती है। तो क्लेमेंट का जो मानना है वो वास्तविकता से बहुत दूर है।
Your Honor, the information that about the money that was received in from Prime in Renish's account was related to legitimate trade. It was money given for the supplies, and I have already provided information about this, and I still say this. And it is also there in Prime's witness statement. It can be confirmed there. And the most important thing is for bank payment processes, there are trade related documents that are required, and whatever the claimant is saying is not true at all.
Well, thank you, Mr. Will.
Yes, Your Excellency, I have no further questions.
That's great. Mr. Mudraj, are we done with the witness?
I'm just waiting for confirmation from those instructing me, but for the moment, I don't have any re-examination.
Well, thank you very much. We'll thank the witness. Thank you, Mr. Mehta, for bearing with Mr. Will question. Thank you, Mr. Interpreter.
Thank you, Your Honor. और योर ऑनर, मैं खाली लास्ट में यही कहना चाहूंगा कि एक एज ए
no comment. Tell him no comment for now.
Okay.
आप टिप्पणी नहीं कर सकते श्री मेहता जी.
His lawyer will do the necessary work. Then that's mean we'll take a break. We will meet again at 2 o'clock Dubai time. Thank you. See you then.
Thank you.
इसी तरह मेरे को उसमें प्रेजेंस रहना है अभी आगे के सेशन में. मेरे को आगे.
And Mr. Hogan.
Your Excellency, what I propose to do is to deal with the purge application first, and then to come on to the sanctions point subsequently, and then you'll hear from Mr. Wheel. I will do my very best to get to an hour. I've been cutting sort of ferociously in the break. I'm probably just over an hour, but I'll be keep regular time checks and do what I can to speed through.
I'll be generous to you. I'll give you 75 minutes instead.
Your Excellency, I'm very grateful. Your Excellency, before getting into the purge application, there are some important preliminary points I wanted to make at the outset. And Your Excellency will have read and heard this morning, Mr. Mehta accepts and regrets his breach of the freezing order when he was on notice of it in November 2020. He didn't act, as he says, promptly to deal with it. He's genuinely very sorry for his breach, as he repeated at numerous intervals in his evidence this morning. And while he takes full responsibility for failing to provide the information required in an affidavit subsequent to the committal order, which was made by Your Excellency on the 19th of October of 2021, he has done everything he can to remedy those breaches and has acted promptly in doing so, swearing an affidavit on the 3rd of November and seeking to purge contempt the very next day. In no way trying to justify his breach, he has attempted to explain in his evidence the circumstances that gave rise to the delay in responding to the freezing order, and the incomplete disclosure given by him in the series of witness statements filed. And the following points, Your Excellency, are of particular importance in that regard. The first is that there has been a very marked change of approach by Mr. Mehta since the committal order was made. He has been able to retain DLA Piper, who, unlike his former legal advisors, have been able to give him appropriate and correct legal advice as to how to respond to the freezing order. Second, the fact that Mr. Mehta has been out of the jurisdiction for some years and is unable to return, as he stated in his evidence this morning, necessarily hampered his ability to provide further information, given his lack of access to documents and computers in the UAE where he'd previously been based. He has therefore provided as much information in response to the information requests in the freezing order and has complied as fully as possible with it. Third, Your Excellency, Mr. Mehta recognises the seriousness of his breach, but it is also important to note that this breach has been in relation to asset and information disclosure. It does not involve the dissipation of assets, and we say that as a consequence of the information he has now provided in his affidavits, he has put an end to those breaches now. It is also important for Your Excellency to frame this application in the broader context of the claims which have been very vigorously pursued against Mr. Mehta by SBM. Your Excellency will of course know about the immediate judgment against Mr. Mehta for breach of contract and fraud. The fraud claim was set aside, the breach of contract claim stood and was never challenged by Mr. Mehta, who accepts liability in respect of it. Despite this, SBM continued to pursue Mr. Mehta in the fraud claim, and while it's a matter for SBM how it exercises its own legal rights, there's been no obvious commercial advantage to pursuing Mr. Mehta in that fraud claim other than to exert pressure on him. A similar pattern seems to be recurring in relation to these contempt proceedings. Mr. Mehta has taken steps to comply with the freezing order and is seeking an order now to confirm that he has purged his contempt. That is opposed by SBM. In addition, SBM asked the court to grant the most draconian punishment available to it by referring Mr. Mehta to the Attorney General. And indeed, SBM goes further than that still and asks the court indicate to the Attorney General that if the court had the power to impose a prison sentence, which it does not, it would have considered an immediate custodial sentence of 2 years to be appropriate. That appears unjustified and unnecessary in circumstances where Mr. Mehta has explained that he has done his very best to put right his admitted prior breaches. It is also a striking feature, Your Excellency, of this application that despite challenging the adequacy of Mr. Mehta's affidavit evidence and asking this court to impose those extremely serious and potentially criminal sanctions on Mr. Mehta, SBM served no evidence at all in response to his affidavits. That includes in relation to matters which are raised by Mr. Mehta in his affidavits and which are certainly within the knowledge of SBM and are relevant to whether he has purged his breach and whether any sanctions should be imposed by the court. For example, whether SBM had knowledge of Mr. Mehta's assets in July 2017, as he claims, and the security interests over those assets in favour of other banks, as he claims. It was also surprising, Your Excellency, to hear Mr. Wheel's line of questioning this morning as to what steps Mr. Mehta had taken to obtain more information regarding his assets. I will just note, Your Excellency, that despite indicating its opposition to the purge application from November 2021, so some 18 months ago, this is the first time these points have ever been raised by SBM. There's never been a request for further information from Mr. Mehta, which would be the ordinary next step in circumstances where there was an issue as to the adequacy of the information provided. I would note in that regard, Your Excellency, that had there been any prejudice to the bank, one would assume that information would have been sought.
Mr. Moderate, I mean, I didn't get the point that where didn't you think he got an obligation to keep updating the court based on that worldwide freezing order about his assets, about the movement of his assets, about whatever happened? I mean,
Your Excellency, he certainly has an obligation to comply with the freezing order, and it's obviously still in place. So he's certainly required.
And then why you think the claimant should have asked for further information, or should apply for another order for another or further information?
Your Excellency, I think the position as we see it is this: as of last Thursday, the skeleton argument from my learned friend was served, and that was the first time when any of the particulars of the alleged breaches of Mr. Mehta's disclosure obligations under paragraph 9.2 and 9.1 and 9.2 in his sworn affidavit were identified. So previously, he didn't swear an affidavit, he was in breach, which he admits. He then swore and served the affidavit in November 2021, and all that was provided by the bank at that stage was an indication that it opposed the application. Now, if it opposed the application on the basis that it says, well, we need to understand what steps you have taken to understand, for example, what account information you were able to recover from the UAE, he could have answered that question. What's instead happened is that it feels now, a week before this this application hearing, which has been pushed off some time by the other side, that effectively there's been a basis to find that there's a breach of the obligations under paragraphs 9.1 and 9.2, and
I don't know, but if you allow me, but I think it's what they say. I thought what they're saying, he is in a continuous breach, and then the affidavit or whatever, which is, as they said, it's not supported, it's not backed with evidence, with documentation, with anything. So from that basis, he's in continuous breach. They have commented in the new affidavit and then said it's got nothing new. He discharged nothing of the burden that's in the worldwide freezing order. And as you have heard in cross-examination, they tried to say none of what you have presented in your affidavit is right, and from that basis you are in a continuous breach.
Your Excellency, that's my understanding of SPM's case. I think what I would just say to qualify that is what they seem to be saying is that the inadequacy is in relation to the extent of information provided, rather than any allegation that anything Mr. Mehta has said is inaccurate. They don't seem to suggest the asset disclosure is wrong. There isn't a suggestion they found another asset which isn't.
And what's the difference between wrong and inaccurate?
Well, Your Excellency, we'll come and look at the Latif case, which has dealt with precisely that point when looking at the question of sanction. But we say there is a very important distinction, and one which has been found by the DIC court.
Yeah, much your hand.
Your Excellency, what I would just propose to do now is look at the relevant legal principles and the purge application. Yes. The first point we note, of course, is that when considering whether Mr. Mehta has purged his breach, the starting point in that regard is the potentially draconian nature of freezing order is such that it must be strictly construed, and that's from the WWRT case, which was cited in my skeleton argument, decision of Mrs. Justice Bacon at paragraph 34, and the page reference in the bundle is 1722. Now, that's perhaps an obvious point, but just coming back to Your Excellency's question a moment ago, it's an important point considering the position that SPM now takes in opposing the application by Mr. Mehta to purge, because as Your Excellency has pointed out, what SPM is alleging is the information now provided by Mr. Mehta is deficient, and effectively he's in continuing breach. But that has a consequence for the burden of proof, and I'll come on to that point as legal principle next, Your Excellency. There are relatively few decisions in the DIC courts on the approach to contempt, but Your Excellency will have seen reference to the Latif and Layla case I've just referred to. There's a relatively long quotation from my skeleton argument at paragraph 39, which is from Latif at paragraph 14. And I just want to pick up a couple of the important quotations from that. And this is a discussion by Justice Wayne Martin as to the principles as far as burdens of proof are concerned in contempt proceedings. And there he says the principles include the principle the onus of proof of criminal conduct rests at all times upon the party alleging the criminal conduct has occurred. And then towards the end of the paragraph, Justice states that in those courts, juries are routinely directed that a person accused of a crime has no obligation to prove anything by way of defence, the point Mr. Wheel actually raised this morning, and no adverse inference can be drawn against a person accused of a crime by reason of his or her failure to adduce evidence by way of defence. And then Justice Wayne-Martin says, in my view, those principles should be applied in this court in the determination of applications for committal by reason of contempt of court. Now, that proposition, we say, also applies in a situation as here, where a party opposes an application to purge contempt, and in doing so, effectively is saying that Mr. Mehta has breached the freezing order despite having served his affidavit evidence. And the consequence of that is that SBM then has the burden of proving to the criminal standard that Mr. Mehta has breached paragraphs 9(1) and 2 of the freezing order, despite what he puts in his affidavits. And to make good this point, Your Excellency, I've cited a recent decision of Mr. Justice Leach in the Alokili and Chauhan case, which is at pages 1683 and 1684 of the bundle for your note. I just want to pick up the two relevant paragraphs of the determination because they're strikingly similar to the position we now find ourselves in. And at paragraph 13, Mr. Ramsden, he was the counsel for the second defendant, submitted that the second defendant has served an affidavit complying with the order. So that's what we say is happening in this case. And then it goes on to say, and then if the claimants disputed this, which is what SBM do, the burden remained on them, the claimants, to prove to a criminal standard that he had not complied with the order since they were in substance arguing that he remained in contempt of court. And then at paragraph 15, Mr. Justice Leach concludes that he accepts Mr. Ramsden's submission that it was the claimant's case, the second defendant remained in contempt of court. So that's the point the SBM makes, that Mr. Mehta remains in contempt of court, and that he was continuing to commit deliberate breaches of the order. And you would have seen Mr. Wheel put his case to Mr. Mehta at the end of cross-examination, saying that he's continuing not to provide information which SBM seeks. And then the final part of paragraph 15 of that decision from Mr. Justice Leach, I also accept his submission that in those circumstances, it was for the claimants to prove to the requisite standard that he remained in contempt. Now that must be right, we say, because in our case, we have already a breach which was established by and accepted by Mr. Mehta, his having failed to serve and swear an affidavit when he first had notice of it in October or November 2020. He has since sworn an affidavit, and SBM's response is that Mr. Mehta is continuing to breach through his failure to comply. And that is an allegation which requires proof to the criminal standard. And Your Excellency, we say that's also very, very clearly consistent with what we saw in Justice Wayne-Martin's determination in the Latif case. The burden of proof in those circumstances rests at all times with the party alleging. Now we will look at the evidence, but one fairly obvious point we can make at this stage is that SBM has served no evidence in response to Mr. Mehta's affidavit. And it's not to say that it would be required to do so in respect to every single point, but there are evidently points which SBM has knowledge of, which it has not served evidence in respect of. Your Excellency, a penultimate and important legal principle when considering if Mr. Mehta has purged his contempt is whether it would have been possible for him to comply more fully with the freezing order than he in fact has done. And the point was put to Mr. Mehta in cross-examination today, and he said that he was not able to do more than he did. Now, support for the general proposition as the consequence of the limitation of one's full compliance with an order can be found in the iPartner case, which is at page 1635 of the bundle. And the relevant paragraph is paragraph 29. That's a decision of Mr. Justice Hamlin, as he then was. And what he says there is that in the present case, the issue is not whether it was impossible to comply with the order, but whether it was impossible to comply more fully with the order. And he goes on to say, in my judgment, the approach should be the same. If there was such impossibility, there may be a breach of the order, but is not a contempt. And that principle is important on the facts of the present case, because while Mr. Mehta has provided information to comply with paragraphs 9(1) and 2, the allegation from SBM is he has failed to comply more fully with those information requests, and that's a point which Mr. Mehta has resisted. while we don't actually accept that he's in breach of a strict interpretation, what we would say is that Mr. Mehta has explained now in his oral evidence that it was in effect impossible for him to do more than he did given his circumstances, and in particular the fact that he was out of jurisdiction, had no access to relevant documents which may have assisted him in that regard. And then lastly, Your Excellency, just on this point about impossibility, you have the reference in my skeleton argument, which is to the Perkier Foods case and the decision of Mr. Justice Chamberlain. And the point there is a very simple one, which is that it's for the applicant, so in this case SVM, to prove to the criminal standard that compliance was possible if it is put into issue validly by Mr. Mehta that he could do no more than he in fact did. Lastly, on legal principles, I won't take you through this in any detail at all, Your Excellency. You will have seen reference to Sahara Energy case in my skeleton argument, and that is I6 in the bundle. And what Mr. Justice Jacobs deals with in that case are some of the factors one might take into account in a decision to accede to an application to discharge contempt. And a couple of the points there were the changing conduct from the respondents, then to comply with the freezing order, the expression of genuine contrition and apology, and the fact that the respondents in that case have not been well advised, what we raised in circumstances of this case. And then lastly, Mr. Justice Jacobs makes the point that there's a public interest, of course, in encouraging individuals to right their wrongs, as it were, and to put matters right after disobeying an injunction. And in that regard, Mr. Justice Jacobs notes the fact there is no disadvantage in a court showing some forgiveness in those circumstances, and we say that's an important factor in these proceedings. Now, Your Excellency, you
Mr. Moderate, I mean, before you move on from here, what I understand you are placing a heavy weight on the affidavit, I mean, filed by your client recently. But my question is that, and then from the basis that you said, well, the burden of proof lies on the claimant to prove the breaches. But do you refer, so are you saying, and then the claimant has to prove, I mean, with a time frame, is their burden of proof like starts after the filing of the affidavit or throughout the whole process? I mean, for the court, I mean, to assess the credibility of your witness, or at least the accuracy, if you would like to say, of the affidavit, would the court should have examined the whole process before it, like since the immediate judgment application, the evidence furnished, then the contempt application, and now the cross-examination, or we need to find a evidence that support evidence furnished by the claimant after the filing of your client affidavit?
You actually, there are a couple of points on the evidence. I mean, you will have seen reference in my skeleton argument to the fact that, of course, Mr. Mehta has appeared for cross-examination. He's given evidence, and the court is absolutely entitled to take a view on the accuracy of evidence. And Mr. Wheel is, of course, entitled to make submissions on that evidence. We don't shy away from that. What we say is that, and we'll come on to a couple of examples of this, where Mr. Mehta has sworn an affidavit, there is no competing evidence presented by the bank on matters which we say it clearly could have provided evidence to challenge. And there are some important examples of that. So it hasn't done that. And one can infer, in the absence of their having done that, that they will accept Mr. Mehta's account of some of those points. Now, in relation to whether or not, because the burden of proof shifts, you then just have to accept Mr. Mehta's evidence. That, of course, isn't right. And as I said, you have contemporaneous documents which may contradict his evidence. The quotation I provided in my skeleton argument from the Mr. Justice Bacon decision refers to the fact it's not an inflexible concept. Of course, then if Mr. Mehta swears an affidavit and says the sky is red and it's blue, then of course the court is not required to accept that because it's not challenged in inverted commas. But the point is perhaps a more closely defined one by reference to the Mr. Justice Leach decision we looked at, which is that by virtue of where we are now, which is that Mr. Mehta has sworn an affidavit, has said that by virtue of doing so, he's purged his contempt. When SBM turns around and says, well, he hasn't done that, he's still in breach. They then assume the obligation to prove that he is still in breach, because that is what is required given the criminal consequences of a finding of contempt. And that's precisely the point Mr. Justice Wayne Martin makes in the Latif case. And indeed, he deals with the fact, in the long quotation, I won't go back to it, with the fact that leading counsel in that case had suggested that by virtue of certain inferences that could be made about the evidence presented, one would have to assume that certain statements made in the affidavit were incorrect. And Mr. Justice Wayne Martin said that was incorrect as an approach.
I see your point here. Thank you.
Your Excellency, just looking at the provision of information requirements then and what Mr. Mehta was required to do, those are at D1 in the bundle, starting at page 688. I don't propose you turn that up, in the interest of time, but there are essentially two obligations which were placed on Mr. Mehta. And the first was that he is required, to the best of his ability, to inform the applicant's solicitors of all his assets worldwide exceeding $10,000. And then under paragraph 9.2, he is required, again, to the best of his ability, to inform the applicant's solicitors of what has become of all of the sums transferred from the claimant to the MBK account, which is an account run, operated, known by a third party, which is Prime, former third defendant in the proceedings. Now, Your Excellency, the best place to start when considering whether or not Mr. Mehta has in fact now complied with paragraphs 9192 is to look at his affidavit evidence. I'm certainly mindful of the time. This is probably one of the points I was looking to cut my submissions down somewhat, and I'll take them briefly. But of course, I would appreciate if Your Excellency has any points that you want to particularly look at in that affidavit evidence. I will be very happy to oblige. Paragraph 1634 of his evidence, he lists all of his and Renish's immovable assets, and these are provided in a summary table under paragraph 16, and they are offices, a residential apartment, and then an oil storage terminal. And Mr. Mehta explains the value of those assets and the fact they were all encumbered with various charges in favour of other banks. That was the same list of assets which Mr. Mehta set out in his second witness statement, but he of course goes on in his affidavit to provide more details in respect to those assets. And so at paragraphs 18 to 20, Your Excellency will see that there is information about the offices owned by him in Executive Towers in JLT. And he explains, Your Excellency will see that those offices were listed in the net worth statement, which was provided to SBM on the 8th of July 2017. That's a point I'll come on to as far as the bank's knowledge is concerned. He then also explains that ICICI Bank had a charge over that asset, and the value of that charge substantially exceeded the value of the asset itself. So you'll see it's 23 million AED is the value of the charge, and the value of the asset is 1.8 million. Mr. Mehta explains that the consequence of that is that by virtue of that asset being sold in partial satisfaction of the charge, is that there would have been no asset against which SBM would have been able to enforce, given the prior charge in favour of the ICICI Bank. And a similar story prevails in respect of the apartment in JBR. There's a reference again to item 4A in the net worth statement where this asset is set out, and that's the statement which again was provided to SBM in July 2017. There is a charge in favour of the Bank of Baroda. Bank of Baroda has 6.2 million dirham charge in its favour, and that of course substantially exceeded the value of the asset. So again, nothing would be realised from the sale which could be enforced by SBM. The same point applies in respect of the HDS Tower in JLT, and again it's the same charge in favour of the Bank of Baroda in the value of 6.2 million dirham. And then lastly, in respect of immovable assets, there is the oil storage terminal in the Hamaria Free Zone, and Mr. Mehta explains this asset was owned by a subsidiary of Renish, Alaska International SNE, and it is Mr. Mehta's evidence that this is referred to in Renish's financial statements at note 15B, and that reference for Your Excellency is B471, And there, Mr. Mehta explains the terminal was acquired using a loan from the United Arab Bank, and the asset was then pledged to the bank. But again, as at the date of the freezing order, the amount due under the loan was some 22 million dirham, and Mr. Mehta's evidence is that he doesn't consider that there would have been any recovery against that asset because it was being auctioned off. Now, what Mr. Mehta says in his affidavit is that he understands that various banks were seeking to auction off that oil storage terminal in order to satisfy various other security interests they had and claims they had against Renish. And Mr. Mehta has indicated that he believes SBM may have been one of those banks. SBM has not said a single thing about whether or not that is right, has not said any evidence in relation to that point. Then, Your Excellency, we have reference paragraph 35 to two other properties. You would have heard Mr. Mehta's evidence today. The property in India, which is referred to, is not an asset of his or Renish's. And the offices referred to in the Hamria Free Zone were only leased, so those are no longer assets of Renish or Mr. Mehta. Your Excellency, you then have various points from 37 about the share interests and other movable assets, which Mr. Mehta says he previously had, but goes on to explain that in respect of all of them, they essentially had nil values. So the shares in ESCO Trading, Renish, Petrochem, Singapore, those, for example, were businesses that were shuttered in July 2018. So, and no cash was realised from the closure of those businesses, and so there would be nothing to enforce when the freezing order was handed down a month later. In respect of Alaska International FZE, the only asset that it had was the oil terminal, and we just dealt with that. That was obviously heavily secured in favour of United Arab Bank. And then you have points to do with vehicles, which none of those are said to be valued above $10,000. Mr. Mehta says he has no savings, and the only cash that might be left would be in accounts, and we can come on to those accounts very shortly. And then in respect of receivables which might be owed to Renish, Mr. Mehta indicates that Prime may owe Renish some money, and then in his second affidavit he confirms that he and Renish are pursuing Prime in the Sharjah courts following the underlying fraud which Renish considers Prime has perpetrated against it. Now, there's some confusion as to the status of those proceedings. Neither I nor DLA Piper are instructed in relation to them, but as I understand the position, Renish's claim against Prime is live, and there is a prospect that Renish could recover its claim against Prime. And if it does, and this is the key point, Mr. Mehta has confirmed to the extent he's able to enforce any judgment against Prime, he will repay SBM what is owed for breach of the facility agreement and his own personal guarantee. And Your Excellency, I will skip ahead because I'm conscious of the time. Paragraphs 38 to 47 set out details of the bank accounts and what Mr. Mehta sent.
But do you remember? I mean, and the question put by the claimants to the witness that he have not mentioned the Sharjah proceeding in his affidavit, but he said he didn't have the resources and the documentation to do so.
Your Excellency, my understanding from Mr. Mehta's second affidavit is that he sought to clarify the position in respect to the Sharjah proceedings. I don't want to pass his evidence for him. I think the key point in relation to those proceedings is that they are live, and there is a prospect that if he were able to recover, and there is a potential prospect of substantial recovery because the claim against Prime effectively is in the same order of magnitude as the claim in these proceedings, then Mr. Mehta will be willing to comply as fully as possible with assisting the repayment of the debt by seeking to enforce any judgment that he obtains on Renish's behalf.
Does the SBM join the proceeding formally? SBM joining that Sharjah proceeding formally?
Yes, yeah, I understand SBM was joined originally. Again, there seems to be some intricacy to do in relation to the basis upon which it was initially joined. The position seems to be it was inadvertently and incorrectly joined as a co-defendant of Prime, and Mr. Mehta's affidavit evidence is that the intention was that it should simply be a respondent. There was then another inadvertent cost order, which I think was sought by Renish against SBM, but that subsequently was also subsequently discharged. So I think that the involvement of SBM was not for the purpose of it being a defendant. It is a necessary participant as a respondent. That is my understanding.
Let's move on.
Your Excellency, just in terms of the accounts, you will see that Mr. Mehta explains that other than 2 of those accounts, he believes that they would all have nil balances. And the reason he believes that is because he understands they will all be subject to attachment orders. And what he says in relation to the other 2 accounts, which do have some funds in them, is that he expects that those 2 may be attached in favour of other banks. He has raised in his affidavit the prospect that SBM may itself have sought to attach or seek an attachment order in respect of his accounts. We are unaware whether or not that is true. SBM is again conspicuously silent on that point, and it may be the case that it has done so, but there's no evidence which it's put in to either contradict what Mr. Mehta says here or to answer that question, as it were. And Your Excellency, just in the context of what we've looked at, albeit briefly,
I'm wondering, is it common for any businesses like to have that many bank accounts in one city or 2 cities?
Your Excellency, I have to say I don't want to be giving evidence on Mr. Mehta's behalf, I'm afraid.
Yes, yeah, it's not explained actually. Yeah, go on.
Your Excellency, just looking at the broad context there, we have then answers to paragraph 9.1, which is the asset disclosure. And in many instances, lots of the information given is in respect of assets which he wasn't actually required to disclose. So nil account balances are not assets which exceed $10,000. The reason he's done that is to try as fully as possible to now comply and to give information which will assist the court and will assist SBM. I should note again, Your Excellency, that a number of the matters referred to regarding asset disclosure are matters within the knowledge of SBM, and there's been no evidence served by them in the purge application which deals with that. And what we would say to that is this, very simple point. If Mr. Mehta was wrong, for example, that SBM was not on notice in July 2017 as to his assets and as to the security interests that attach those assets, it seems to us that SBM would have served evidence challenging his account because they would have said it was wrong, because he would then have been in breach of the order by giving a misleading statement in an affidavit. They have not done so, and we say it indicates that Mr. Mehta's evidence on these points is correct. And in fact, when we come to look at what is actually challenged by SBM in respect of Mr. Mehta's affidavit evidence, what it really comes down to is we didn't give us more information. It's not a challenge we see to the veracity of the information he has in fact provided. As to paragraph 9.2, Your Excellency, Mr. Mehta has given information again to the best visibility regarding the sums transferred from SBM to Prime's accounts with MBK. Mr. Wheel made much of this point in cross-examination earlier today and suggested that Mr. Mehta's statement in paragraph 49 of the affidavit was untrue, because Mr. Mehta has actually confirmed that sums were transferred between Prime and Renish in the ordinary course of business. But Mr. Wheel only showed Mr. Mehta paragraph 49 of his affidavit and not paragraph 50. And I think that may shed some light on what his evidence actually is. At paragraph 49, Mr. Mehta explains that had he provided the information once on notice of the freezing order, which he says was in October or November 2020, he would have indicated that he did not know what happened to those funds, but does not believe that any of those funds were transferred to him or Renish. So that's what he said he would have done at the time. At paragraph 50, he then qualifies that statement by explaining, in reference to the Grant Thornton report prepared in the underlying proceedings, that the only funds which would have been transferred to Renish by Prime would have been in the ordinary course of business. So what he's saying is what he then understood by reference to the Grant Thornton report subsequently. Paragraph 49 is what he says he would have said when he was on notice of the freezing order in October, November 2020. Plainly, there's no contradiction between those paragraphs. One reflects knowledge at one time, one reflects knowledge at another time. In response to paragraph 9.2, Mr. Mehta gives further details about the 8 companies identified in the Grant Thornton report, which are said to be recipients of funds from Prime's account. And what he does there is he explains, by and large, there's no relationship at all between those companies and Renish. So you have Astron Global, Helwas Energy, Nova Petrochem, Novan. Mr. Mehta confirms he has no knowledge of those companies at all. He confirms he's aware of Kellerex, but that is a business owned by an unrelated party. He similarly confirms that Renish has done business with Neon Petrochem, but that too is unrelated to Renish. And in relation to PetroHub, which was an oil trading business owned by the former CEO of Renish, Mr. Mehta confirms it was a separate company and not an asset of Renish or Mr. Mehta. And it's an important point to note, Your Excellency, that in his judgment, Justice Lord Angus Glennie took an approach consistent with Mr. Mehta's evidence in this regard and made no findings at all as to the ownership or control by Renish of any of the entities which are listed there, other than PetroHub Energy, which Mr. Mehta accepts was owned by the former CEO of Renish, Mr. Ahmed Ayaz. You're actually 2 final points on purge application. Oh, sorry, before I do that, two points I just want to make in respect to paragraph 9.2. The first is that Mr. Mehta has explained that he has no access to documents and the computers which remain in the UAE. So he has not had the benefit of refreshing his memory of any documents that could assist his evidence as to funds which may have transferred. And those transfers are now some 5 years ago. And second of all, and it's an important point we shouldn't lose sight of, it's reasonable to conclude...
Sorry, but what do you mean, like, the information is in his computer?
Well, Your Excellency, as a matter of his ability to meet the burden of disclosing information under paragraph 9.2, of course, what he's being asked is information about the destination of funds which have moved from a Prime bank account. Now, essentially, what Mr. Mehta is left with is only his memory of transactions which he has said, crucially, he has no knowledge of at all, because of course he's not the owner of Prime. He's not Prime is a separate business. So
right. Is that right? But we know the movement of data that usually happen through information source, could be email, messages, things which he should have an access to. What if the bank wants to send a statement? They will send it through. They will not like plugged it into his hard disk, isn't it? They would email him or something. He must have kept an email or anything. I mean, this is, I think, it's not a science rocket.
I understand the point. Mr. Mehta's evidence, of course, is that he hasn't been able to communicate with the banks. Part of that's come down to, and you actually will be familiar with the truth of Renish emails and the collapse of the business in July 2018. And part of it is a consequence of Renish losing its trading license and having an inability to access information and data from afar. I mean, the fact that he's not in the jurisdiction obviously is unhelpful, but Mr. Mehta's evidence effectively is he's been unable to get other
right. Well, we didn't have a single email or message or text message from him to the bank, where the bank refused to deal with him because he have a expired trading license or anything, isn't it?
You actually, Mr. Mehta's evidence, as I answered it from his cross-examination today.
Well, I tell you what, at the end of the day, I have to analyze Mr. Mehta's evidence. Is that right?
That's quite right, Your Excellency.
Yeah, it's not something I should have taken for granted. I mean, that's what the court should give a certain weight to evidence before it.
And we appreciate that point, Your Excellency. The second point, just in relation to paragraph 9.2, is a point I just raised, which is that, of course, it's reasonable to conclude that Mr. Mehta would only have limited knowledge of the destination of these funds in any event, because, of course, they were amounts held by a third party, Prime. And Mr. Mehta's evidence is the only funds which would have circulated from Prime to Renish were those which were the consequence of genuine business transactions in the ordinary course of business. So in those circumstances, we say, Your Excellency, Mr. Mehta has complied with paragraphs 9192 to the best of his ability and has purged his contempt in that regard. There are two final points I want to make on purge application, and the first is this point about the burden of proof. Your Excellency will recall the point I just made from the Latif case, where Justice Wayne Martin determined that an application for committal is made on the basis that alleged contemnor has committed a criminal offence, and therefore the burden of proof remains on the party alleging that offence. And Your Excellency will also recall the decision of Mr. Justice Leach we referred to previously about how that applies in circumstances where effectively there's a renewed challenge to a breach of a freezing order. The threshold is a very high one, of course, Your Excellency, and considering the gravity of the allegations and the potential consequences for Mr. Mehta, it is important that SBM therefore take very seriously that obligation to prove that Mr. Mehta has again, as they say, or continues to breach the freezing order. And as I said, Your Excellency, SBM has not said any evidence in response to points which it evidently could have dealt with. The detail of the opposition to the purge application was only revealed for the first time last week. Until then, all Mr. Mehta knew from a letter sent by SBM solicitors on the 14th of November was that the application would be opposed. In the interest of time, I just want to pick up a few examples from my learned friend's skeleton argument just to make good this point about having not met this burden, because some of these points are important. So paragraph 22, SBM complains about the lack of information regarding Mr. Mehta's interest in the Indian property listed in his affidavit. Now that submission is misconceived because Mr. Mehta explained, and explained again today, that neither he nor Renish has any interest in that property. He's not obliged to set out all the assets in which he has no interest. And the reason he did so was because that asset was referred to in the freezing order, and so he dealt with it and explained it's not his asset. At paragraph 25, SBM states it does not accept that it held or holds all the relevant information relating to Mr. Mehta's and Renish's immovable assets. Now, this kind of gets to the point I've been going to earlier, Your Excellency. It's a surprising assertion to make in a skeleton argument in circumstances where no evidence at all has been submitted to support that position. If it is now being suggested that the financial statement and the net worth statement which Mr. Mehta had provided to SBM was not actually received by SBM, that should have been provided by way of a witness statement. It should not be made in submission, and certainly not in the circumstances of a contempt application. At paragraph 26, and then a similar complaints are made through paragraphs 27 to 30, SBM states that Mr. Mehta has failed to provide documentary evidence regarding the sale of assets, so documents which support his position. But of course, Mr. Mehta has explained, and he reiterated in his oral evidence, that he has no relevant documents because of his circumstances, because of his not being in the jurisdiction. And we said that is an important piece of evidence because it goes to the extent to which he is able to comply more fully with the order. If he's not in the jurisdiction, he has no, and he says he has no access to records and evidence, then the court has to take a view that what he's saying is actually wrong. But other than effectively just being told that he's lying by Mr. Wheel, there is nothing to contradict his evidence. He doesn't have those documents. That's his position. That's his evidence. And then lastly, Your Excellency, at paragraph 31, in relation to Mr. Mehta's evidence, he had no way of checking bank account balances in Dubai. Again, the suggestion is that Mr. Mehta has not given any evidence as to whether he attempted to check these balances. But Mr. Mehta's evidence was that no one of the banks in Dubai would take his calls following the collapse of his business in July 2018. And he mentions the fact of not having a trading license, but he also says that he was able to get account information effectively through a third party, so an individual who was a former accountant at Renish. And that's how he went about getting that information. So it's not quite as straightforward as saying, well, he hasn't done anything to get information. He has obviously done what he can do.
It's quite weird. I mean, if the person in charge himself cannot get the information, I wonder how third party can get that kind of information.
I don't want to characterize Mr. Mehta's evidence. My understanding was that was evidence which was perhaps already in in the possession of that individual. So it's historic information which he was then able to obtain from an accountant who previously worked at Renish. Your Excellency, there is just, I do need to skip ahead because of time. There is the second point, which is in relation to the standard of compliance, which we've just touched on. You have the point about strictly construing the freezing order.
I can't hear you.
Apologies, Jackson. I appear to have
Yeah, I see. I lose
muted
you for a couple of seconds. Yes, yes.
The second point is about construing paragraphs 9, 1 and 2 strictly and understanding the obligation that Mr. Mehta was required to fulfill, and that required him to provide information to the best of his ability. But I won't belabor the point about why he was curtailed in doing so. You have that point. But those circumstances are important because they do go to how the court should view the test for compliance. We've looked at the iPartner case and the decision of Mr. Justice Hamlin that there should be no finding of contempt where it is impossible to comply more fully with a freezing order. And we say the extent the court considers there's any deficiency in the information provided, there'll be no contempt because Mr. Mehta has complied as fully with the freezing order given the circumstances. Coming back again to the burden of proof, Your Excellency, and we've looked at the Perkier Foods case. Given the potential for criminal sanctions, the burden of proof remains with the party alleging breach to prove to the criminal standard that compliance beyond the steps taken by Mr. Mehta would have been possible. And with respect to Your Excellency, we say SBM has not discharged that burden. Your Excellency, those submissions in respect of the purge application deal now with sanctions. Actually, there's one final point on purge, and it's a point which wasn't put to Mr. Mehta, but it should be dealt with in submission because it was in Mr. Wheel's skeleton argument, and this is to do with meeting the costs obligations associated with ensuring Mr. Mehta's compliance, because there is some suggestion in the Gulf Wings case that contempt will only be purged where costs of contempt proceedings have been met. Now, Mr. Mehta has accepted in his affidavit in relation to his failure to comply, once on notice, he would bear cost consequences and doesn't shy away from that. He would not resist a cost order, but would simply note that his best avenue of repaying that amount will be through the successful pursuit of his legal claim against Prime in the charge of proceedings. I recognise what the Gulf Wings case indicates, that costs expended as a result of contempt would need to be met in order for a breach to be purged. But there are some important points to note about that determination. The first is this: that was an obiter point from the DIC Court of Appeal, because in that case, the order was set aside because the claimants had not had an opportunity to make submissions at first instance. So there wasn't actually a binding determination that one has to discharge, has to meet a cost order in order for contempt to be purged. And we say that it has to be a principle which is sensitive to the application to the facts of a particular case. And for this reason, it can't be a binary principle, because otherwise it would actually be impossible for a party which had no means or was impecunious to ever purge its contempt. And that can't be right as a blanket proposition. And what we would say then with respect is that because it cannot be a blanket proposition, it's not one a court should adopt from an obiter determination in the Court of Appeal. But in any event, as I've said, Mr. Mehta would do what he could to comply with any cost order to the extent he would come in funds to do so. And lastly on that point, Your Excellency, we say that it doesn't go to, it may be the case that his contempt is then purged in respect of his compliance with paragraphs 9.1 and 9.2. It may be that cost is just a different point. On sanctions, Your Excellency, legal principles, I think, are largely agreed between the parties. There are effectively three avenues open to Your Excellence. Either no sanctions should be imposed, which is what Mr. Mehta suggests should be the case. A fine should be imposed, or the matter can be referred to the Attorney General. Unlike the English courts, DIC courts do not have power to commit party in breach to prison. But of course, it's important to note that a reference to the Attorney General will necessarily be for an investigation of a potential crime. And so we say it has at least, it may be the antecedent step, but it has the necessary consequential impact and is treated in the decisions as being the more serious punishment. And you'll see that from Mr. Justice Wayne Martin's decision in the Latif case. There is some tension between the parties on one point, which is whether an inability to pay a fine would provide a basis for a referral in and of itself. Your Excellency has the reference to the Crystal Muse case from my skeleton argument, which states that it'd be wrong to impose a custodial sentence simply because a party in breach is unable to pay a fine. And with respect, we consider that approach to apply the DIC court as well, because while Justice Wayne Martin indicated at 146 in the Latif case that a fine would be futile in that case, it is also clear the judge determined that the seriousness of the breach independently justified a referral to the Attorney General. And if you look actually at the paragraph 18 of his judgment, he sets out the principle. And what he says is that references to the Attorney General may also be appropriate in cases in which the court considers sanctions available to the court, which are essentially limited to imposition of a fine, are inadequate to appropriately reflect the significance of the contempt committed. So what one looks at is the significance of the contempt, not whether or not party can pay a fine. As the points of mitigation, which I'll address Your Excellency on, you have both the Latif case and then the Oliver and Sheikh case, which is a decision of Mr. Justice Nicklin. And a few of the points of significance as far as mitigation are concerned are an admission of breach, which Mr. Mehta has done. He's admitted he breached the freezing order in the first place. An admission or appreciation of the seriousness of breach. Again, Mr. Mehta appreciates that and has explained his understanding of the seriousness of what he's done. Any cooperation to mitigate the consequences of breach, he's explained that he's willing to cooperate going forwards, and in particular will cooperate insofar as he can for to meet the judgment debt by reference to anything he recovers in the Sharjah proceedings against Prime. And then lastly, a genuine expression of remorse or a sincere apology to the court for his behaviour. And Your Excellency will have heard numerous points today in his oral evidence, his genuine contrition in this regard. And then lastly, just on the law, the Aspect Capital and Christensen case stands for the proposition that the court should also take into account the defendant's character and relevant antecedents when considering what, if any, punishment would be suitable. Your Excellency, the submissions fall into two parts. The first is dealing with mitigation. The second is just dealing with the appropriateness, or we say inappropriateness, of the sanctions which are available. It's worth noting, of course, the primary purpose of sanctions jurisdiction in cases of contempt is to punish historic breaches, and we don't shy away from that, but also to secure future compliance. And that second purpose, we say, has now been fulfilled by virtue of Mr. Mehta's remedial steps in swearing his affidavit and providing the information previously sought. While we recognise the court does need to consider sanction for breaches of freezing injunctions, it has the power to offer mercy to those in breach who have shown genuine remorse and who are seeking to rectify those breaches. And we would say in those circumstances, it would be an unfortunate outcome, as well as a disincentive to other parties in similar situation, to impose a sanction punishing Mr. Mehta now, after he has taken steps to purge his contempt. Before I look at mitigation, I just want to look at the Latif and Layla case, because it is a case which is squarely on point and is relied on heavily by my learned friend in his submissions. And what it is relied on to support SBM's position, the court should refer Mr. Mehta to the Attorney General for breach of the freezing order. We say, if anything, on closer inspection of what was decided, it actually supports Mr. Mehta's case that a referral to the Attorney General would not be appropriate as a sanction in this case. Now, the first point is just to note there are three distinct groups of respondents in Latif. The first is described as the Layla corporate entity, and that entity was found to have undertaken a deliberate and continuing strategy of dissipating assets to related corporate entities in breach of the freezing order against it. That does not apply in our case. The second group of defendants are Lamy and Labib, and they were found to have failed to comply with the freezing order on time, but they were also found subsequently to have failed to list other assets which the claimants had themselves discovered. So the numerous assets located in Dubai, Turkey, Bahrain, which the two defendants there had not disclosed. And again, this is not a case, not the case with Mr. Mehta. He's given full disclosure of his assets. And indeed, we don't understand his allegation by SBM that the extent of his asset disclosure is deficient insofar as failing to disclose assets. And the last defendant, Laik, which is the most similar to the situation of Mr. Mehta and Renish, the asset disclosure information was not said to be and therefore not found to be inadequate, but was simply provided after the deadline imposed for the freezing order. And similarly, we say Mr. Mehta's affidavit was filed late, but the consequence of that was that he has admitted breaching the freezing order in the first instance, but he has now corrected that and given information which we say closes that loop and satisfies the requirements of paragraphs 9.1 and 9.2. The second important point in respect to the Latif case is that in the case of all of the defendants, Justice Wayne Martin held there were no mitigatory factors at all. And it's important to reflect on that because the allegations of contempt in that case were all contested. No admissions were made, let alone recognition of the seriousness of the breaches, and there was no attempt to mitigate the damage caused, and there was no apology. And that was even in the case of the last defendant, Laik, which had belatedly disclosed. There was no apology proffered, no explanation for delay, and no admission of breach. And by contrast, and we'll look at the mitigatory factors in a second in Mr. Mehta's case, he has apologised sincerely. He has admitted his breach and recognised the seriousness of it. He has sought to explain the breach without shirking responsibility for it, and he's undertaken to cooperate to assist SBM going forwards. The third point, Your Excellency, just in respect of the Latif case, as a result of those very serious breaches, Justice Wayne Martin concluded that the appropriate sanction was a reference to the Attorney General. But it's worth noting his rationale in relation to the breach by Laik, which was the last defendant we looked at, which is the most similar defendant in the circumstances. Now, paragraph 155, what the judge explains is that if the only case before the court had been that relating to Laik, he might have considered the imposition of a fine. However, Laik is the corporate manifestation of the individuals involved in the commission of the other contempts found by the court, and Laik's conduct is appropriately viewed in that context. As those contempts to be referred to the Attorney General is appropriate for the contempt committed by Laik to be referred to the Attorney General as well. So Justice Wayne Martin's view was that a belated disclosure of assets was, on the one hand, seen as being less serious than dissipation of assets and less serious than deliberately misleading the court by swearing a false affidavit. But also, as the sanction which would apply in isolation, he considered that it might have justified the imposition of a fine, but not a reference to the Attorney General. And we say that that is the position that Mr. Mehta finds himself in. Indeed, we say Mr. Mehta should be viewed in a far more favourable light, considering the significant mitigating factors which were completely absent in the case of Laik, as Justice Wayne Martin concluded. Your Excellency, with that context, I want to look at the mitigatory factors, and you have these in the skeleton argument, so I'll be able to go through them relatively quickly. The first,
you got 15 minutes.
Excellent. Thank you, Your Excellency. I'll do my best. I think I should be on track. The first is that Mr. Mehta, we say, has purchased contempt, and if Your Excellency is with us on that, that is a point of particular significance. As the authorities explain, a primary objective of the court's jurisdiction to order a sanction is to ensure compliance with orders, and the committal order has had that effect. And Mr. Mehta's conduct has taken a positive turn since the committal order was made. We say he has done everything he can, considering the circumstances, and he has undertaken to continue to comply to assist the court and SBM moving forwards so that the ultimate purpose of the freezing order, which is essentially now to fulfill a judgment debt against him, can be met. And we say that conduct points very squarely against imposing a sanction. The second point, Your Excellency, is that Mr. Mehta has apologised, and he has done so with genuine sincerity, and he's conveyed that clearly today on a number of occasions to the court. Third, and related to Mr. Mehta's apology, there are 2 points of mitigation to which Justice Wayne Martin referred in Latif. The first is that Mr. Mehta has admitted his breaches, and while he attempted to explain how they came about, he fully accepts responsibility for them. The second related point is that he recognises the seriousness of the breaches, and I've already contrasted the position in the Latif case, where none of the defendants ever apologised or even admitted their contempt, less still acknowledge the seriousness of the contempt. And just for Your Excellency's reference, paragraphs 144, 151 and 154 of Justice Wayne Martin's decision. The fourth point, with respect to his previous legal representation, Mr. Mehta had not been properly advised when he was first on notice of the freezing order. And we say that much is fairly obvious by virtue of the fact that he filed and served a witness statement in response to the freezing order, rather than the affidavit as required, and because he failed to provide the information sought in paragraphs 9.1 and 9.2. And he accepts responsibility for that failure, but that's an important point. And I won't take you to it, but there was an additional authority circulated by my learned friend yesterday evening, which is a chapter of G on commercial injunctions, and the reference, and the point is made squarely there, that where he's acted on mistaken legal advice in that context, and we say it applies with greater force where that advice is effectively not good, it should be taken into account by the court. And what we say then is that with the benefit of adequate and correct legal advice following the issue of the committal order on the 20th of October, he took very prompt steps to remedy the breaches and to swear an affidavit, and then sought to purge the very next day. The fifth point is that other than the costs which we referred to of securing Mr. Mehta's compliance, we do not believe that SPM has suffered any harm as a result of the breaches. And this is actually quite an important point as far as the omission of SPM's responsive evidence on some of these matters, because Mr. Mehta's case is that from July 2017, SPM was aware of all of Mr. Mehta's assets by virtue of not least the 2 documents which were exhibited in his first affidavit. One is a net worth statement which he provided as part of the due diligence exercise when the financing he obtained from the bank was being considered, and the second are accounts for the subsequent year which Mr. Mehta believes the bank also had, which give rise to a number of points, but in particular they reveal the fact that those assets were certainly known to the bank. The security interests in respect to them were referred to in those documents. And Mr. Mehta had gone further and said, insofar as the shares and accounts are concerned, and particularly the accounts, he's put into issue in his affidavit whether or not the bank has sought to obtain attachment orders against any of those accounts, and there's been no response from SBM as to whether or not that's true. And one might assume, in the absence of any evidence, that perhaps Mr. Mehta's evidence in that regard is accurate. But what we say then in terms of harm is that there's nothing which has really been provided by the bank to explain that position. In fact, the evidence, as far as it goes from Mr. Mehta and those documents which show that the details of assets were provided previously, would suggest the bank has always been aware of the relevant assets and may well have taken steps to enforce insofar as it could do once the freezing order was obtained. The sixth point is that Mr. Mehta and Renish have not dissipated any of the assets in the freezing order, and you would have seen again the reference in Latif to the significance of that conduct as far as seriousness when considering breach of a freezing injunction. The seventh point is that Mr. Mehta has explained he will willingly cooperate with the bank, including in recovering assets that might be used to meet the judgment, and in particular any judgment debt he obtains from prime in the Sharjah proceedings. And of course, that's important because Mr. Mehta's cooperation in this regard may allow SBM to recover a substantial proportion of its judgment debt if he succeeds in those chargeable proceedings. The eighth point, Your Excellency, is that Mr. Mehta has been, we say, unfairly tarnished in these proceedings. Until the collapse of his business in July 2018, his reputation was unblemished. He ran a very successful business over a number of years, which had revenues at their peaks of over 2 billion dirham and net profits of some 50 million dirham. He was able to secure substantial financing for a number of financial institutions following exercises of due diligence, which presumably SBM itself undertook. And despite being out of the jurisdiction, he now is taking every step he can, first to clear his name in respect of the fraud claim against him, which has been taken to the Court of Appeal, as Your Excellency knows, but also insofar as trying to purge his contempt in respect of the freezing order. And lastly, Your Excellency, just in terms of mitigation, it is important, we say, to take into account Mr. Mehta's current situation. He's explained in his oral evidence and his affidavits the desperate position he is now in. When his business collapsed, he lost his entire livelihood, which was in Dubai. He now resides in India with the support and generosity of family and friends. And as I say, he's doing everything he can now to clear his name and put the situation right in the UAE. And the sanction against him in those circumstances is disproportionate. And we say, well, he served to set Mr. Mehta back further. And accordingly, we would respectfully submit, Your Excellency should not order a sanction in this case. There are 5 minutes left, and I will canter through final points on appropriateness of the two sanctions which are available, which is the second part of my submissions in this regard. The first we say is that a fine, we agree with SBM on this point, is likely to be self-defeating and inappropriate in the circumstances. We think it's a more appropriate sanction than a reference to the Attorney General, but ultimately, Mr. Mehta has indicated, at least at this stage, he would not be in a position to meet an immediate fine. And of course, any fine would dilute the assets which would be available to SBM to satisfy its judgment debt to the extent Mr. Mehta is able to obtain such assets, I think principally in respect to the charge of proceedings. The fact that a fine would not be suitable does not, with respect, render a reference to the Attorney General appropriate, and I've referred Your Excellency to the Crystal Muse case and also to the Latif case, where the inquiry of the court is to determine whether or not the breach is sufficiently serious for a reference to the Attorney General to be appropriate. And in fact, referring just back to the reference to G, which my learned friend served overnight, at subparagraph 12 under chapter 9, G states that where a fine is an appropriate penalty, a contender's lack of financial means will not furnish a basis for imposing a custodial sentence as an alternative. In such circumstances, the appropriate course is to make no order. So if Your Excellency decides that neither sanction is appropriate and Mr. Mehta would not be able to meet a fine, then no order is the appropriate order to make. And then lastly, Your Excellency, in terms of the reference to the Attorney General, we say this would clearly not be appropriate. You have, just for your note, and I'd just ask Your Excellency to remind yourself of these paragraphs 4176 of Mr. Mehta's submissions, which are behind volume D, tab 12. The submissions as to the general inappropriateness of reference to the Attorney General in this case and why it really won't be fit for an order now. Just taking some of those points quickly, for the court to include a reference to the Attorney General as an appropriate sanction, it should be satisfied that the conduct is so serious that no other penalty is appropriate, and that's the approach from Oliver and Sheikh, paragraph 17. And indeed, it's clear from the Latif case that Justice Wayne Martin considers the referral to the Attorney General to be the most serious punishment in the DIOC court arsenal. And I've explained the various reasons why the conduct of Mr. Mehta is not so serious that no other penalty is appropriate. You know, he hasn't dissipated assets. He sought subsequently to purge his contempt. He's seeking to cooperate going forwards. All of those mitigating factors come into play there. The second point is whether this is a situation of last resort, and that's again a reference to the Oliver and Sheikh case. again, clearly it isn't. He's sought to comply and will continue to comply with the freezing order going forwards. He's undertaken to do so. And he has an important part to play going forwards insofar as SBM being able to ultimately obtain recovery for its judgment debt. The third point is whether a custodial sentence would be important in the circumstances, and that's obviously by proxy to a reference to the Attorney General, because of course that would lead to a criminal investigation. And again, I won't repeat myself, but given the numerous points of mitigation, and I think in particular the nature of the breach, we say it wouldn't be an appropriate sanction. The last point, which requires just a tiny bit more unpacking, is whether or not really the practical consequence of referral to the Attorney General will serve any purpose, let alone a desired outcome. Now what SBM has relied on in Latif is to show that you don't need to identify a particular criminal offence in order for referral to the Attorney General to be appropriate. But in reality, one does need to consider whether a referral to the Attorney General without any identifiable criminal offence or practical likelihood of investigation or conviction is appropriate. And one needs to consider that should a referral be made to the Attorney General, it's unlikely to result in Mr. Mehta being indicted and referred to the Dubai Criminal Court, which would be necessary for criminal conviction. But if he were to be, so even assuming an offence can be identified and investigated, that process is likely to take a substantial period of time, as well as drain both the Attorney General's and Dubai Criminal Court's resources. It will require an investigation to be opened, probably involving the police. And seeing as Mr. Mehta is not in the jurisdiction, he will be unable to defend himself because, as you will see from submissions, mitigation provided by him under Article 160 of the Criminal Procedural Code of Dubai does not allow a party to defend criminal proceedings in absentia. So plainly it would be undesirable for referral to be made in circumstances where there would be a criminal trial of Mr. Mehta for non-disclosure of information relating to assets which he'd be unable to defend. There's also the question of potential appeals which may arise on conviction. And the likelihood really of an investigation by the Attorney General is remote, we say, considering two important points. First, Mr. Mehta, we say, has taken steps to purge contempt. So there will be an essential element of one criminal offence, which is the one cited in the VIH case, which Articles 141C and 153 of the Dubai Penal Code, which essentially is a non-disclosure of assets. That will be missing because, of course, he will have purged his contempt by disclosing his assets. The Attorney General may also be unlikely to investigate the non-disclosure of assets in circumstances where SBM, we say, had the relevant information related to those assets at the time the freezing order was granted, albeit not provided in the form of an affidavit. And the other alternative criminal offence, which has been trailed previously, and again rise in the VIH case, is Article 269 of the Federal Penal Code. But of course, that relates to dissipation of assets, and Mr. Mehta has explained, and I don't believe SBM is even taking a point on this, that neither he nor Renish have dissipated their assets in breach of the order. So that wouldn't be on point. And in those circumstances, it would be inappropriate, we say, to refer the matter to the Attorney General, considering in particular that he's purged his breach and where there's no readily identifiable criminal offence, which would necessitate an investigation. And Your Excellency, I think I've run 1 minute over. I appreciate your indulgence, but unless I can be of any further assistance, those are the submissions on behalf of the second defendant.
Thank you very much. I think we've done well with the time management. Soldiers. I'm proposing to take a 5 minute break, and then we'll come back in 5 minutes. We'll hear from the claimant.
And what's my time allocation, Your Excellency, just so I can plan?
You should have a similar time if you wish.
I'm grateful. Thank you.
Thank you very much. Good afternoon, Mr. Will.
I'm grateful. I see my learned friends back.
Please.
Your Excellency, our position is as follows. We submit that the matters relied on by Mr. Mehta do not come close to purging the contempt which the court has already found to have been committed. And we say that, if anything, his recent evidence serves only to emphasise the gravity of his earlier breaches, and his recent evidence is both false and materially incomplete, and to that extent exacerbates the breaches that the court has already identified. And in relation to sanction, our position is that this is a case in which a referral to the Attorney General is the only appropriate sanction. And in my respectful submission, it would send a very dangerous message to litigants in the DIFC courts if a deliberate breach of a freezing order, which a litigant has not attempted even to address for over a year. You'll recall that he discovered the freezing order at the latest in October, early November 2020, and yet his first affidavit was produced in November 2021. It would send a very dangerous message to litigants in the DIFC if that was not responded to by this court with a reference to the Attorney General. And if I could just put in context this case by reference to Latif, the delay in Latif in complying with the disclosure order, I think, was 30 days. In this case, it's 1 year at least. So with that high-level overview, I'm going to address very briefly some of the themes in my learned friend's submissions. I'm then going to address you on the evidence that you heard from Mr. Mehta, and then I'm going to set out the legal principles and the application of facts to those legal principles.
Well, Mr. Sawir, I would appreciate if we focus on the purge application, not into the contempt application, the current one, which is.
Yes, I'm prepared. Well, the purge application is essentially the meat of what's before the court. I can deal with sanction relatively briefly. So there are 4 points that my learned friend started with or recurred throughout his submissions. The first is that he emphasises that Mr. Mehta has given a sincere apology. In my submission, actions speak louder than words. Anyone can get a lawyer to draft a statement saying that they're sorry, but you judge the sincerity of that apology not by the words written on the page, but by Mr. Mehta's conduct. And when you look at that conduct, you see a witness who has no interest in assisting the court with his evidence and who continues to lie on oath. The second point my learned friend makes is that there was no evidence from SBM in relation to the purge application. The short answer to that is that SBM has no relevant evidence to give. This is Mr. Mehta coming to court claiming that he has given full disclosure of matters relating to his assets. We've got nothing that we can put forward to prove a negative. All we can do is test Mr. Mehta's evidence. And we've done that. And in my submission, we have shown that Mr. Mehta's evidence is hopeless. And I'll return to that in due course. The third point my learned friend makes is the burden of proof point. Now, our position is that as a matter of law, we do not bear the burden of proof. It is for Mr. Mehta to establish before the court that he merits forgiveness because he has righted the wrongs that have occurred as a result of his breach. And in relation to that, the first instance judgment in Alakali relied on by my learned friend, and my submission should not be followed in the DIFC because the Court of Appeal's judgment in Solodchenko, which addressed how purge applications were to be dealt with, was not cited. And in my submission, that is the more persuasive authority. But I don't want to trip up, or I don't want the court to trip up on a technicality, because in my submission, the evidence in any event amply demonstrates to the criminal standard that Mr. Mehta and Renish are in continuing breach of the freezing order, and I invite the court to conclude accordingly. The fourth point, and this was a point addressed towards the end of my learned friend's submission, is effectively Mr. Mehta says that the court shouldn't impose any sanction whatsoever. So first of all, he says, don't impose a fine because I can't pay it and it will eat into the recovery from SBM, and don't refer to the AG. Now, in relation to the reasons why you shouldn't refer to the AG, it was submitted, well, in reality, the Attorney General isn't going to press charges, and therefore this is all a pointless exercise. In my submission, that is a fundamentally bad point. This court should not be prejudging the careful analysis that will be given to this case by the Attorney General of Dubai, he will consider carefully the evidence, whether or not potential criminal offences have been committed, and if so, how that should be taken forward. It is not for this court at this stage to prejudge the outcome of the Attorney General's analysis. Rather, the question for this court is, has the gravity of the breaches that have been established and the failure by Mr. Mehta properly to address those breaches justify the matter just being referred to the Attorney General for consideration? And in my submission, the answer to that question is plainly yes.
Mr. Wheel, if you allow me, I mean, in this point, I mean, when the courts come to conclusions, for example, to decide contempt and then to decide, let's say, sanctions, the court won't decide sanction unless it's very much sure that the contempt is there, the breach is already happening. Where what would remain to the Attorney General is just to refer him. Maybe I'm asking you to refer him to the court, and the court would decide the punishment.
That's not how it works in my submission. First of all, you have already, in your carefully written judgment of October of 2021, concluded that deliberate breaches of the freezing order have been committed. So that's essentially the conclusion of the fact-finding exercise. And the next stage is sanction. And when you come to consider sanction, you have fairly limited options, unlike the position in England and elsewhere, in that you cannot impose a custodial sentence. The maximum step that the court can do here, which arguably is unsatisfactory, but it's a function of the legislation, all you can do is simply refer the matter to the Attorney General, and it's then left to the Attorney General's discretion as to what to do next. But in my submission, it would be quite wrong not to complete that first stage by, as my learned friend invites you to do, speculating on what the Attorney General might decide to do with this case. All you need to decide is the situation sufficiently serious as to merit consideration by the Attorney General? And in my submission, the answer to that is self-evident. Now, I want to address you on the evidence that you heard from Mr. Mehta, because that has a bearing both on purge and sanction. In my submission, it was clear that he is a fundamentally dishonest witness. His answers to my questions were evasive, and very often he would refuse to answer my question and would criticize the questions having been put to him, even though Your Excellency directed him to answer them. He showed no interest in my submission in assisting the court by providing full and accurate information. I invite the court to conclude that he was lying in relation to the attempts that were said to be made to communicate with banks and other third parties. And in support of that, I draw the following matters to the court's attention. First and foremost, there is not a single document evidencing any such communication. As Your Excellency rightly observed, one would have expected a WhatsApp, an email, or a letter. You have absolutely nothing. The second point is that Mr. Mehta's evidence fundamentally changed when he was asked the same question. He would say, first of all, effectively that he did nothing, but that was because of a mental trauma that he was suffering from. The second iteration of his evidence is that he couldn't contact the bank because his email ID or his trade license had been revoked. He then pivoted to say that he'd asked a friend to make contact on his behalf, but that is an inherently implausible suggestion, given that the bank is plainly not going to deal with a third party rather than the client themselves. And the final iteration of his case, or his evidence, is that it would have been pointless to contact the bank because they wouldn't have responded. So in my submission, his evidence was inherently implausible, self-contradictory, and unsupported by a single document, and I therefore invite you to conclude to the criminal standard that he was lying about his attempts to contact banks and third parties. His evidence was also fundamentally dishonest in relation to what was said about the proceedings issued in the Sharjah courts against Prime and SBM. The evidence he gave in his first affidavit was categorical and gave a very clear impression that no steps had been taken or could be taken to pursue Prime because Renish did not have sufficient resources to do so. That evidence was signed or sworn by Mr. Mehta in November 2021. Less than 5 weeks earlier, in late September 2021, Mr. Mehta himself had instructed lawyers to issue proceedings in the Sharjah courts. Contrary to what's said in his second affidavit, that cannot be explained as an inadvertent error, as he puts it. It is a straightforward lie, and there is no other way that the court can conclude. Another point that emerged from his evidence was the extraordinary revelation that for the last 20 years, he has been living in an Indian property owned by his wife. And you'll remember, first of all, that Mr. Mehta refused to disclose who the owner of the property was. Then under compulsion, he was forced to reveal it was his wife. And then he sought to pretend to the court that his wife that there was a realistic possibility that his wife would evict him from the property. All of that information came out for the first time today. It was thoroughly unsatisfactory, and in my submission, the court should conclude to the criminal standard that Mr. Mehta has a very real property interest in that asset, which he has failed to disclose, and that the evidence in his first witness statement and his first affidavit that he has no assets outside of the UAE was a false statement, because this Indian property that he's lived in for the last 20 years is plainly an asset in which he has an interest.
Well, he didn't say that, Mr. Weed. I mean, he didn't say. He just clearly said. He said before, I didn't have any asset in India. Even if, and now I'm staying with my wife in my wife's house, which she bought by her own money. And I didn't know that this is contradicts what? I can't recall.
His evidence is that he has no assets outside of the UAE.
Yeah, but saying the property is in his wife's name, that doesn't mean it's his own property, isn't it?
No, but he had never previously said either that he'd lived in it for the last 20 years or that the property was in his wife's name. It's now emerged for the first time.
But it's I think it's kind of usual that when you cross-examine a witness, it's naturally you would come across a sort of information that it's never been said, written, or presented, and that's the purpose of the cross-examination.
Well, not in this case, Your Excellency, because in this case, Mr. Mehta has claimed to have provided full information about all of his assets. And in my submission, it's highly material that his principal residence for the last 20 years has, well, first of all, that he's lived in that for the last 20 years, and second, that it's in his wife's name. Because that undermines any suggestion that there's an arm's length relationship between the owner of that property and Mr. Mehta, which is the impression that he'd previously tried to convey. And is a further aspect of his evidence in my submission that is unsatisfactory.
I see.
Another aspect of his evidence that is unsatisfactory is the suggestion that he has no income, no bank accounts, and that all of his money essentially is received in cash by family members. In my submission, that is inherently implausible and something to which the court should attach no weight. So I've got limited time, so I've only given you a few aspects of his evidence, but in my submission, you heard his evidence, and you should have no hesitation in holding to the criminal standard that the evidence that he gave was in material respects false and incomplete. Now we want to move on then to the applications that are before the court. You're familiar with the background, of course, Your Excellency, because you not only made the original freezing order, but you also heard the trial of the contempt application in which you found a deliberate contempt to have been committed. Perhaps the starting point then is to look at the contempt judgment, which is at page 779.
Yes.
And you can see from the front page that Mr. Mehta there was represented by Mr. Peter Duckworth, who's an experienced English barrister, and that he was instructed Ashish Mehta and Associates, who are DIFC qualified lawyers. Now, my learned friend and his client, on the one hand, haven't expressly waived privilege, but on the other hand, have sought to tantalise the court with the suggestion that Mr. Mehta wasn't properly advised by these lawyers. In my submission, the wording of the freezing order is very straightforward, and there is no question that these lawyers would have been in a position to, and did in fact, explain what the freezing order meant to Mr. Mehta. And without any express waiver or any disclosure of documents, you should attach zero weight to the suggestion that Mr. Mehta wasn't given proper advice or didn't understand the terms of the freezing order. Now, if you turn please to paragraph 10 of your judgment, which is on page 784.
Yes.
You there say, I accept Mr. Wheel's submission that freezing injunctions were rather toothless if the information orders were not complied with. Not only would the claimant be left in the dark as to what assets it may be able to recover, but also the claimant would be unaware as to whether the substantive orders were being complied with. And that's an important point, and Your Excellency's judgment is in good company insofar as there are plenty of other authorities, including most recently in Latif, where the importance of disclosure provisions in freezing orders have been emphasised. Then if you turn please to paragraph 15 on page 785.
Yes.
You say that you held that the second defendant had the opportunity to submit a witness statement in response to the committal application and to attend court to give oral evidence. But in fact, he didn't bother to turn up to the hearing. You see that in the last line. I take an adverse inference of the decision of the second defendant to not attend the hearing or give any oral or written evidence. And then paragraph 16 is important. You say there that the first and second defendants' representatives have been on the record by the time of the hearing for 3 months, presumably having been provided with instructions before then. You don't accept that any party can be so laissez-faire about their assets that they cannot provide a partial account. It was said numerous times that the defendant's ability to comply had been hampered as a result of partial legal representation because of funding issues, but you didn't accept that, and you went on to find a contempt of court. Then further down in paragraph 19, you found that they took no steps to comply with the order, that they had a reasonable period with which to comply but have not made any meaningful attempt. And then in paragraph 21, you found that several breaches had been deliberately committed and that you were satisfied to the criminal standard that that was so. And finally, in paragraph 23, you found them jointly and severally liable for costs. And in relation to that, as with much else, they have not paid a single penny or attempted to ascertain what our costs are so that they can be satisfied. Now I want to turn to the authorities next, and in my submission there are two key authorities that you will derive particular assistance from. The first is the Court of Appeal of England's decision in JSC, BTA Bank and Solodchenko, and the second case is the Latif and Yella case in the DIFC Court of Appeal, both of which say essentially the same thing. But I want to start with Solodchenko, if I may, at page 1350. And I should say that much of this is common ground between my learned friend and I. So paragraph 45 explains that there are two purposes behind sentence for the law of contempt. First, it's punishing the contemnor and deterring others. And second, it's enforcing compliance or coercing defendants to comply. But the deterrence of others in my submission is an important point, and it's a point I made at the outset of my submissions, which is the message you will be sending to litigants of this court if deliberate breaches of freezing orders aren't met with significant sanction. Then please, if you could scroll down to paragraph 51 at the bottom of page 1351. And this is very important. What the case, so the Court of Appeal surveys the authorities, and it says what they show collectively is that any deliberate and substantial breach of the restraint provisions or of the disclosure provisions of a freezing order is a serious matter. Such a breach normally attracts an immediate custodial sentence which is measured in months rather than weeks and may well exceed a year. So either a breach of the restraint provisions or a breach of the disclosure provisions that's deliberate and substantial engages that principle. Then if you look at paragraph 54, sorry, 55, this is dealing specifically with non-compliance with the disclosure provisions of a freezing order. You see that from the second line of 55. And it said there that freezing orders are made for good reason. Any substantial breach is a serious matter which merits condign punishment. Condign punishment normally means a prison sentence. There may be circumstances in which a substantial fine is sufficient. For example, if the contempt has been purged and the relevant assets have been recovered. And that latter clause is important. And then 3, where there's a continuing failure, the court should consider imposing a long sentence, even the maximum of 2 years. But implicit with that is even where the failure is not continuing, some sort of sentence is appropriate, just a shorter one rather than a longer one. Then if you scroll down, please, to paragraph 67. This is the interaction between the punitive aspect to a sanction and the coercion aspect. And it's the sentence beginning, on the other hand, there is also a public interest in requiring contemnors to serve a proper sentence for past non-compliance with those with court orders. The punitive element of the sentence both punishes the contemnor and deters others. And then at paragraph 69, the court distinguished the punitive aspect of the sentence. So for past non-compliance, it was suggested that 9 months imprisonment was appropriate, even if the breach was remedied. And then it was only in relation to a continuing breach that a sentence of 21 months was considered appropriate. So in my submission, that's an important set of principles of direct application to the present case, because what it makes clear is that even if, which we dispute, the breach has been remedied, this was a serious and deliberate breach of a freezing order for which a serious sanction is warranted. Now, my learned friend says, well, no damage has really been done here because the relevant events took place in 2018 and it wouldn't have made much difference to the bank even if it had had full information by Mr. Mehta promptly after he became aware of the freezing order. In my submission, that's a fundamentally bad point for a number of reasons. First and foremost, it's not open to a defendant unilaterally to breach an order simply because they consider that no damage is going to be suffered by the claimant. The court considered it appropriate to make the order in this case, and it's incumbent on the defendant to comply with it. But it's also a bad point on the facts, because as you'll appreciate, this was a complex fraud in our case, where there was a network of companies and people involved in dissipating assets. And getting as much information as soon as possible is critical to the asset tracing exercise. And it simply doesn't lie within the mouth of the defendant to say that the bank couldn't have done more if it had been provided with proper information. If nothing else, it's now common ground that Renish itself received $7.8 million that derived from the prime account. We've still not been provided with proper information as to what's happened to that money. All that Mr. Mehta says and has said is that it's the ordinary course of business. With respect, Your Excellency, that is not good enough. This is the sole owner and director of Renish. He must know what's happened to that money. And in my submission, the court should conclude to the criminal standard that he has deliberately withheld relevant information that would enable that money to be traced. Now, just on this point, I need to address a point made by my learned friend in relation to Mr. Mehta's first affidavit. And on that, please could you turn up page 25.
Yes.
And I hope you're looking at a page that includes paragraphs 49 and 50.
I do.
So my learned friend sought to rely a number of points, and it's important that the court is clear about the chronology. So at paragraph 49, Mr. Mehta is saying that back in October 2020, to the best of his knowledge, none of the sums paid into the prime account had been transferred to him or to Renish. Now in paragraph 50, he says, I have since seen the Grant Thornton report, which appears to have addressed this issue. Now that's important for this reason. The Grant Thornton report wasn't produced until June 2021, whereas Mr. Mehta's defence was signed by him in February 2021. And it's important that we look at what's said in his defence, and that's at page 734. And I hope you can see subparagraph 4 at the top of that page.
I do, yeah.
And what he says there is none of the disbursements, save only the 3 mentioned in paras 56 to 57, totaling 7,886, was to or for the benefit of Renish. And these were strictly transfers in the ordinary course of business. So by the time he filed this defence, and you'll see his signature at the bottom of it, Mr. Mehta already knew that those sums had been received. and he already knew sufficient information about them to plead a positive case that they were in the ordinary course of business. In my submission, therefore, the court can only conclude that the evidence that he gave is dishonest. His knowledge and information has nothing to do with the Grant Thornton report. He has always known that this sum had been received by Renish, and yet he's chosen to provide no information about what's happened to it. Now, I want to move into the detail again of the purge application. It's worth perhaps just starting with the application notice, which is on page 5. Or it was on page 5, I think it might now be page 6. So the sole basis for the purge application is the affidavit dated the 3rd of November 2021. It's not suggested that there's any other matter that's relevant to the purge. Now, I'm going to explain to the court briefly why the affidavit of November 2021 is unsatisfactory. But before we even get there, in my submission, the purge application doesn't get off the ground because Mr. Mehta is unable or unwilling to remedy the losses which have been suffered by the bank as a result of this contempt. Now, my learned friend referred to the Court of Appeal's judgment in the Gulf Winds case, which of course is the leading authority in this jurisdiction. He tried to pass off the comments as mere obiter, but I don't think my learned friend went as far as to say that they were wrong. But in any event, in my submission, it would be a bold thing for a judge of this court to dismiss a clear conclusion by the Court of Appeal on the basis that it's obiter. And in my submission, the Court of Appeal's reasoning should be followed by this court. And the Court of Appeal in Gulf Wings made very clear that in order properly to purge contempt, you have to put the claimant in the position that they would have been had the contempt not been committed. And that includes reimbursing them for financial losses, including costs which flow from the contempt. Now, my learned friend made a submission without any authority to the effect that that can't be right, because if the defendants don't have assets, then it will be impossible for them to reimburse the claimant in relation to their loss. In my submission, that's a bad point. It doesn't matter whether or not they have assets. If a defendant is coming to court essentially asking for forgiveness and maintaining that they've remedied all of the difficulties caused by their original contempt, they have to put those matters right. Otherwise, they have not purged their contempt. And what one can see that must be the right conclusion if one considers a different set of facts. Suppose that the deadline for compliance with an injunction is absolutely critical, because unless something happens before a certain date, the claimant is going to suffer irremediable loss because they will have lost out on a contract or whatever. If a contempt of court results in that claimant suffering loss, it is and should be impossible for the defendant to purge contempt. The only way in which they can properly purge contempt is to put the claimant in exactly the position that they would have been had the contempt not been committed. And that has not been done in this case. And therefore, on the authority of Gulf Wing, the application simply doesn't get off the ground, even if you were satisfied that Mr. Mehta had given full and truthful evidence. But he hasn't. And I've already...
I would like to ask you, I mean, what suppose the defendant, what suppose the defendant should have remedied from the contempt? We're not talking about recovery of the relevant assets, isn't it? We're not talking.
We are, in my respect, sufficient, because we have lost an opportunity. The bank has lost an opportunity to trace assets, and it's lost that opportunity for a period of over a year. Now, if the bank had been told at an early stage, these are all the bank accounts, this is exactly where the money that was paid into Renish's account has gone, the bank could and would have taken steps to track down the ultimate recipients. Even now, Mr. Mehta is refusing to tell the court and the claimant what has happened to the money that Renish received. And to that extent, we have lost, the bank has lost at least a proportion of the 7.8 million. And therefore, to put right the remedy, the contempt that's been committed, in my submission, he does need to satisfy at least a significant portion of the loss that we've suffered, as well as reimbursing the claimant for their costs. The claimant, I can say on instructions, has incurred a 6-figure sum in these contempt proceedings. Mr. Mehta has not made proposals to pay a single cent of those costs. And therefore, in my submission, he doesn't get past first base, even if his evidence was full and complete, which it's not. So just very briefly dealing with the deficiencies in Mr. Mehta's evidence. I've already taken you through the highlights, but he's made no attempts to contact relevant third parties. All he does is make assertions about the status of his bank accounts, the various properties of his that have been sold. There's no documents, no information, and in my submission, the court can attach no weight to what he said. In relation to the Sharjah proceedings, he's given false evidence. And as I've made the point a number of times, and perhaps this is the most important point, it's section 9.2, paragraph 9.2 of the order. Even now, he's not said what's happened to the monies received by Renish. So not only has he failed to remedy the financial losses suffered by SBM, he still hasn't provided correct and complete information. So for those reasons, you should dismiss the purge application in my respectful submission. But in any event, even if contrary to what I've just said, he has remedied the wrongs, which he hasn't, there's still a very important penal element to the sanction which the court should impose. Because if this court is to allow litigants deliberately to breach freezing orders and do nothing for over a year, then in my submission, the DIFC court's reputation will have taken a backward step. And in relation to the sanctions that should be imposed, the key authority is the Solodchenko authority, and also Latif and Liela, and also the passage from Gion Injunctions, which I don't think you've seen because it's not referred to in the Skempton argument, but I just invite you to turn to page 1745.
1745.
Yeah.
Right.
And 2 lines from the top, you'll see a paragraph beginning, the committal order will normally be fully appropriate where there has been a deliberate breach of a freezing order or a search order, even if, in the meantime, the defendant has sought to rectify the prejudice suffered by the claimant. And although that is a statement of English law, it's entirely consistent with what's said in Latif, which I'll just take you to very briefly, I think at 1558. Sorry, it's 1559. There's a heading, General Principles, at the bottom of that page relating to penalty. And 141C makes the point, essentially adopting Solodchenko into DIFC jurisprudence.
But see, what I'm saying, Mr. Will, I mean, you might say this, you might argue that despite the fact that a defendant would purge a contempt, but the court still has the discretion to decide whether to impose this sanction with different leverage, taking into account the overall pictures as suggested in the judgment you just referred me to in 1745.
That's right. You do have a discretion, but it's a discretion that's got to be exercised in accordance with the principles established in the case law. And what the case law makes clear is that where you have a deliberate and substantial breach of a freezing order, even if attempts have been made to remedy the prejudice, that in itself is an extremely serious matter that merits a custodial sentence, not just to punish this defendant for having shown contempt to Your Excellency's previous order, but to deter other litigants. Because if the position were otherwise, litigants in the DIFC court think, oh, we'll deliberately breach orders, we'll do nothing for a year, and the court's not going to do anything, provided that at the 11th hour, we produce a more fulsome witness statement or a more fulsome affidavit. And in my submission, that is simply wrong. So to the extent you've got a discretion, that would be outside of a reasonable exercise of it.
I see, but this case is completely not dealing with a situation where a defendant has satisfied a burgeoning condition, isn't it?
It's not, you're
Yeah.
correct. And to that extent, my learned friend was sort of wrong to suggest otherwise. This was not a purge case.
It's about the penalties for contempt only.
It's about penalties, exactly.
I see.
But the short point you do get from this judgment is that even if a breach has been remedied, a deliberate and significant breach in itself normally attracts an immediate custodial sentence, a for sure right, a reference to the Attorney General in the DIFC. Unless there are any particular questions you have, Your Excellency, that was all I was proposing to say in reply.
Well, not at all. Thank you very much, Mr. Will. I think I have heard enough from you today. Let me look at my notes if I see if there is anything I can ask about for any of you. Well, sorry, I just come through a note where the defendant did not want to spell out his wife's name.
Yes, I don't seek an order at this stage, but we might need to come back to court to seek some further information from the defendant in light of what he said today.
Yes. Well, I think, yes, I have enough. I've heard enough. I would reserve for judgment. It will probably be after the Eid holiday. Not exactly when, but I hope it's soon. The registry would let you know when exactly. Thank you very much for your presentation. Have a good day ahead for all. Thank you.